Page number 2, item 8 to 13. Page number 3, item 14 to 19. Page number 4, item 20 to 25. Page number 5, item 26 and 27.
Item 27. Item 27. I have some personal difficulty.
Pardon to mention, Your Lordship.
Tomorrow.
Is it a writ appeal?
Writ appeal. Pardon to mention, Your Lordship, one matter that is with regard to recruit.
None appears even today for the petitioner. By the order dated 17/7/2023, we had observed as follows. Quote, if on the next date there is no representation, this writ petition will be dismissed for non-prosecution. We are left with no other alternative but to dismiss this petition for non-prosecution. Accordingly, it is ordered. Next.
Item 2.
Item 2, I am filing the date chart today. Lord, can your lordship take it tomorrow?
Tomorrow, is it possible? I don't think so. Mr. Roth, tomorrow it may not be possible.
Day after?
21st. Can it be? 27th. 28th. Oh. 1st of August. We'll take up the matter on 1st of August.
Okay.
Can I pray, my lord? He has got to serve a copy of the W also. That is not there. If you see, and we don't have a copy of it also.
Served since 2021. Still then I will start another.
Nothing so with CNF.
Mr. S.P. Ratho and counsel. Bearing for the petitioner has prayed for some accommodation. Appellant has prayed for some accommodation today. Prayers can sell out. Date chart come, note of submission has been filed in advance for the petitioner. After serving a copy to Ms. S. Patnaik, an additional government advocate, is appearing for the respondents. So let the matter be listed on 1st of August 2023. I am not reflecting this. Please supply the copy in the course of the day.
I will supply.
This date chart comes as taken on record. Next.
Item 3.
May it please your lordships.
Yes.
Now, this is a writ appeal wherein this appellant has challenged the order of the Honorable Single Judge, who has upheld the order of the collector, who has affixed a liability on the appellant, to which the appellant is not at all liable. The brief facts is, my lord, there is a coal mine area named as Talavera,
Yes.
which was under the occupation of the respondent number 1, Hindalco. In 2015, some villagers, those who have made the private opposite parties herein, approached the collector with a grievance petition that soil overdumped has been made, the mining soil, on their lands. So an inquiry was conducted. The collector directed the sub-collector to make an inquiry whether that is true or not. And in the inquiry, it was found that Hindalco has done this, the overdumping of material. Then Hindalco was also questioned. Hindalco said, yes, there has been some mistake there because of rain or something that has slipped into the lands of the private opposite parties.
Yes.
That remained as such, but no action was taken by the state authorities. So the private opposite parties were constrained to approach this honorable court in another WPC, which has been also tagged to this record, my lord, today. There, the opposite parties prayed that direction be issued to the opposite parties to work out and direct the Hindalco to remove the dumped materials. That in that petition, Honorable Justice, my lord, Justice C.R. Das was the then. He directed now the Hindalco was a party. Hindalco, let the Hindalco give an answer to this. In between, what has happened, your lordship may see the list of events I have filed in date chart. This mining lease was handed over to the erstwhile appellant which was GMR Chhattisgarh Energy. The coal block was allotted in the year 2015, late 2015, that is about in the month of June. Now your lordships on the date chart will find that this lease deed was entered into by the appellant along with the government on 10/6 1/4/2015. Thereafter, operation of the mining was started on 5/8/2015. But by that time, already representation was there that Hindalco was the entity who's liable for the overdumping. That is the case of the opposite parties. Thereafter, petition was filed before the Honorable Court at serial number 10, your lordship may see.
Yes.
2/5/2016. Till then, they have throughout maintained that it was Hindalco only. In the subsequent writ petition, GMR Chhattisgarh was made a party because by that time he came into operation. But that was later. Now your lordship question arises. Who is liable to be affixed with the liability which he has done during the mining operation? Now this is answered by Coal Mines Special Provision Act. Perhaps I have given a slip for your assistance.
Yes.
You may see section 14.
What is the
Of
name
the
of the act?
Coal Mines Provisions.
What is the name of the act?
Coal Mines Special Provisions Act 2015.
This is not the act. This is a different act.
If your lordship so desire for
All right, just
paucity
show
of time,
us
I can
the
hand over
copy.
my book.
As per the date chart, Mr. Rath,
My lord,
you say 1/4/2015, it was handed over to Hindalco.
the vesting order handed over, the site was handed over, but the mining operation commenced after the mining permission was given. That I have mentioned in 7,
Handed
serial
over-
number 7 of the.
Handed over by virtue of what?
It was handed over, my lord, soon after the vesting order.
No, by virtue of what?
The vesting order
There
itself.
is a letter. There is a letter or some document saying that it has been handed over or they have taken possession.
No, it was, my lord, by Hindalco had handed over the mining operation area by virtue of that letter, but that letter is not available with me.
You are saying, okay.
Hindalco had handed over.
Yes. By Hindalco.
That
And
what
after-
happens, my lord.
And after 31st March 2015, the GMR has taken over the management.
GMR was given the vesting order in the month of March 2015, but mining operation commenced in the month of August 2015.
What provision you are mentioning?
Section 14, my lord.
The liabilities of the prior relatives.
Yes, my lord. There your lordship may see section 14, clause 3. Section 14, subsection 3, my lord.
So it completely prohibits no remedies shall be available against the successful bidder or relative. This is succeeding bidders. You read the relevant part, although you don't have the book. I'm just returning it. You a little slowly read, we'll catch
Fine.
it up.
Section 14,
Yes.
liabilities of prior allottees. Notwithstanding anything contained in any other law for the time being in force, no proceedings, orders, or attachment, distress, receivership, execution, or the like suits for the recovery of money, enforcement of a security or guarantee, except as otherwise provided for under this act, prior to the date of commencement of this act, shall lie or to be proceeded further with, and no remedies shall be available against the successful bidder or allottee, as the case may be, or against the land and mine infrastructure in respect of Schedule 1 of Coal Mines Act. Schedule 1 of the Coal.
Against successor, there cannot be any liability.
Yes, well, this is prior to the commencement of the act, the liability stands with the successful bidder as on date
Yes.
for the Schedule 1 coal mines
Yes.
area. So in Schedule 1 coal mines, Talavera is there. Now my remedy lies here, my lord. Subsection 3. May I go to subsection 3?
Yes.
3 says every liability of any prior allottee in relation to a Schedule 1 coal mine in respect of any period prior to the vesting order or allotment order shall be the liability of such prior allottee. It shall be the liability of the such prior allottee and shall be enforceable against it and not against the successful bidder.
That is the succeeding the.
Yes.
These
So
company or
liability,
whatever the.
my lord, this is exactly my point. The liability of the prior allottee remains intact even after the bidding is over. So
Right.
in my case, Hindalco was the prior allottee and he had done the overdumping of the.
The relevant part of the judgment.
Yes, my lord.
Okay, print it, take the print out, keep it with you.
Annexure 9, page 66. Behind read, ma'am.
Only the relevant paragraph.
Relevant paragraph, my lord. I rely on this. This is an admission by the Honorable Single Judge that it is the prior allottee himself. That is paragraph 6. I would start from there. Petitioner is subsequent allottee. On perusal of earlier writ petition of private opposite parties, it appears same was made against State and Hindalco. Annexure 4 in the writ petition is letter dated 10 June 2015 of Sub-Collector Sambalpur addressed to Hindalco. Text of the letter is reproduced below. One Ranjit Kumar Maji, Rajesh Kumar Bohi, and Lalit Kumar Vishwala of village Hinda have filed grievance petition before the collector Sambalpur for removal of overburden, OB means overburden, dumped material from their Rayati land. This matter was inquired by the Tahsildar Rengali and confirmed the fact of overburden.
You just straight you come to the fag end of the paragraph 6.
My lord. There is no disclosure.
There is no disclosure.
To show that a petitioner on taking possession of the mine caused inventory of the waste that already stood dumped by Hindalco on private land. Here my submission to this, my lord. It is not anybody's case that GMR has dumped it. It is from the very beginning, the private opposite parties have made grievances and thereafter have approached this honorable court stating that Hindalco is the person responsible. There is in the writ petition itself also, the counter filed by the opposite party discloses the same. They say, the opposite parties say that we do not know why the collector is after GMR Chhattisgarh and affixed liability when we are asking them to proceed against Hindalco. That is their specific stand in the counter affidavit matter, as I have also filed that. Now,
All right.
and surprisingly, your lordship may see.
In which paragraph of the counter? This is the counter affidavit of the opposite parties 2, 3, and 4.
My lord.
Come to the relevant paragraph.
Paragraph 5. Paragraph 5, it is it is submitted, page 74.
Hindalco was given the directions to remove. That is the letter of the collector, sub-collector to remove to the Hindalco to remove the dumped materials from the liability land of the present deponents.
Direction complied, but till date the direction has not been complied.
Okay.
This is one. Now your lordship may see paragraph 9, where I say that why the collector is after this.
Heard Mr. Anupam Ratho and counsel appearing for the appellant. Stuff. By means of this intercourt appeal, the judgment dated order dated 23/9/2022, delivered in WPC number 13989 of 2018 by the learned single judge has been challenged. Mr. Roth, learned counsel, in the course of his submission, has stated that the respondent's number five, 6, and 7 in the counter affidavit filed in the writ petition has clearly stated that the prior LOT was given notice to remove the dumped materials from the royalty land belong to those respondents, but that was not complied with. Stuck. On the face of such material, Mr. Roth and counsel has contended that in view of the subsection 3 of section
14
of give the name of the
the
act.
coal mine special provision within bracket Act
Give
2015.
name. Take the name from there. Stuff. The succeeding LOT cannot be settled with any liability in respect of the liability which was in the prior LOT. Stop. Admit. Issue notice since Mr. D.K. Mohanty.
5 to 7.
Learned additional government advocate appears and waves notice for respondents number 5 to 7. No formal notice in respect of those respondents is called for. However, the appellant shall supply one copy of a memorandum of appeal to Mr. Mohanty, an additional government advocate in the course of the day. So for the remaining respondents are concerned, appellant shall take steps for service of notice on them by registered post with AD within 3 days from today. Notice is made returnable on 28th of August 2023. Stop. In I 333, it is a 333 one up to 2022. Is an application filed by the appellant NWA 1377 of 2022 for staying the operation of the impugned order. Staying the order dated 18/4/2018 issued by the respondent number 6, Annexure 8 to the writ petition, and the order dated 23/9/2022 was by the learned single judge in WPC number 13989 of 2018, Annexure 9 to the writ petition. Stop. Issue notice. Issue notice since Mr. D.K. Mohanty, learned counsel, appears for the state opposite parties. No formal notice is called for on those respondents. However, the remaining opposite parties shall be served with notice, and these applicants shall take due steps for their service within 3 days from today by registered post with AD. In the meanwhile, the operations of those orders within Annexure 8 and Annexure 9 shall remain suspended till the next date. This order is. It was already in the same field that has been substituted. Just see the comment. In view of the substitution, last in the IA is I number, it is not
1996.
1996, 2020.
1996.
1996 of 2023. This was actually allowed and disposed of. The substitution
Yes, that had been allowed in last statement.
View the order dated 3/7/2023.
Was allowed by the order dated
3/7/2023.
3/7/2023. 3/7. Yes, 3/7/2023. The said miscellaneous application. 3/7, no, just a minute. 3/7/7.
3rd July 2023.
Okay.
Nothing remains to be decided. So it's postponed.
Just in view of the order passed on 3/7 such and such, this IA has become inessential as the substitution has already been given effect by your amendment in the memorandum of appeal. Accordingly, this stands disposed of.
Anjan copy.
Item 4,
Lordship has fixed it to date next
28/8, no?
28
August
August.
28, yes. Item 4.
Item 4, Your Lordship, had an RTI application. I had sought a cabinet notification dated 13 July 2020.
Who are you?
I'm a petitioner in person, Your Lordship, appellant in person.
Okay.
An RTI application was filed by me seeking a cabinet notification dated 13
We are
July
in appeal.
2020. That was,
Mr. Khandatre, we are in appeal.
yes, Your Lordship.
If you want to
Writ petition
introduce-
was also rejected.
Huh?
Writ petition was also rejected.
That is why
Your Lordship.
you have to challenge the grounds on which the writ petition has been rejected only. You cannot expand the scope of the appeal by filing a new document. Because to file a new document in the writ appeal, you need to take leave from this court. Otherwise, you cannot file it. Because when a single judge did not decide your case on the basis of the document that you are going to file. It is an intercourt appeal. We follow certain disciplines. We are giving you some adjournment. You take proper advice.
Okay.
Let the matter is at the request of the petitioner in person, Mr. Sanjeev Kumar Khandatre. Let the matter be listed again on 16th of August 2028. Stop. We shall provide no further accommodation.
It is 13th of August, my lord.
16th of August.
16th.
Yes. Mr. P.K. Pari and counsel appears for Union of India respondents, i.e. respondents number 1 and 2 on advance notice.
item 5,
Yes.
Here I am questioning, lords, the validity of the order of the honorable single judge under annexure 19, page 194. My lord, the facts of the case is, my lords, the private opposite party appointed as a lecturer
Yes.
and he was terminated on the ground that by practicing fraud, he got appointments. The fraud question is very much there. And as against that vacancy, I was appointed in the year 2010 and have been uninterruptedly continuing. And he filed writ application questioning the termination, validity of termination. And I, the sub-collector who was the special officer, he in a liberal consideration allowed him to join in his former post, even if the termination was not passed. And while the matter was pending for lordships, I challenged that orders because once he joined, I lose my job. And at the stage of admission, without issuing notice to my employer, that is governing body, to the government, the honorable single judge said that my appointment is invalid. More particularly, the Honorable Singular said that matter is not admitted, no notice was issued. And I am continuing for last, say, 10 to 2023, last 13 years, uninterruptedly. And at this juncture, while holding that the termination order is bad in law, at the same time, even if neither the case with the governing body nor even the case with the contesting opposite party, that I was appointed illegally. My appointment was never questioned by anybody. But the Honorable Single Judge, without giving opportunity to anybody, even my employer, even if my appointment joining a resolution is there, that my appointment is valid. Now the held that my appointment is invalid. For that sake, Lordship kindly see the impugn order first. That is 194 page.
Why the two private individuals have been added as the respondent? One is Lavlojit Raut and another is Bikram Kumar Patnaik.
Bikram Kumar Patnaik is the contesting, who is the initially appointed. He is the private opposite parties.
And the other
Here
person,
the opposite party was there.
and the other person,
Bikram Patnaik is.
He was the initial appointee. He was the initial appointee and he was terminated. I think the back end I am continuing. And he is the Millard's ex, he is the sub-collector, ex-sub-collector by name I have given the person.
Why by name? That is my question. Because I do not find any allegation of malafide. Why by name a officer?
No, malafide allegation something is there because he was by that time.
You are not the writ petitioner, just.
No, I am not the, I am challenging the next second read. I am challenging the very order of that Lingara Raut, where at the last minute, at the verge of retirement, he passed the orders directly in the opposite party to join in my post. I am questioning that orders. That is the writ application. Lordship kindly see 134.
You have also filed one writ application.
Yes, combined that was the order was passed. I have also challenged the order of the sub-collectors.
Come to this.
That 1130, my writ application there. Two writ applications, that analogous hearing. That is my writ application number is 3115/2022. Page Millards 194.
Oh, yes.
Yes, that is there. And Lordship kindly permit me to press the matters. Since the issue involved.
Common judgment.
It is common.
But are you challenging both the order passed in both the writ petitions?
Yes, both the writ applications are challenging.
By one appeal?
By one appeal, because they are common orders.
So you are making your own rule. Unfortunately, you cannot do that. You have to file another writ appeal. That is why I am asking you. You are combining the parties in one writ appeal. Take time and think over it. Otherwise, you have to say that I will maintain this appeal. I will just abandon the challenge against the other writ petition. You cannot do that.
I am confining so far as my validity.
Try to understand, it is a procedural law. The two writ petitions, one common judgment was passed. That doesn't give you any right to file only one appeal to challenge the order passed in both the writ petitions, though it is in the common judgment. This is well settled law. You have to file two writ petitions. We will be also passing one single common judgment for disposing both the appeals, but you have to follow the process. Because two writ petitions carry the two different sets of facts. Your case and the case of these respondent number 6 are not on the different footing or the same platform of facts. Just think over and passing over the matter. It will come again on the 1st of August.
Let's say call it any day I will file the second that will come. Let's say I am filing that another writ appeals. Let's say call it any day tomorrow day after.
All right, let the matter be listed on 25th of July, 2023. You just think, oh, this is not the way, these things will be complicated, unnecessary time will be wasted.
if you file, you mention it. All right, simply adjourning.
At the request of Mr. S.K. Das.
As to Mr. D.K. Mahapatra.
Mr. D.K. Mahapatra, Lord Counsel appearing for the
Appellant.
appellant. You have to file another.
Yes, I filed that.
Right.
Item 6.
May I please? No, this petition is filed, my lord, based on annexure 8, leave granted by this honorable bench, my lord.
Okay.
Page 32. The sole grievance in this application, my lord, he sought for a promotion from the day his juniors were promoted.
Why this writ petition will be taken up by a division bench?
No, because it's a judicial.
A judicial
Judicial
employee or judicial employee?
Yes.
Okay.
He is working in grade 3, my lord, in Sonpur.
Okay.
Lordship, can I come to page 17?
Age?
17, my lord. Admittedly, my lord, a proceeding was there. That was ended, my lord, with a punishment of censure, minor punishment of censure. But when that proceeding was there, my lord, seal cover was never followed. There is a government direction which is applicable to this case, my lord. That says in the event a minor punishment of censure is given, they have codified, my lord, 3/4 punishment. Then his case to be, seal cover is to be opened and he should be given promotion. In the event he is found suitable by the committee. That is basically the case. That's why, my lord, lordship is granted me that liberty to file a separate application.
You are Mr. Tripathi?
My lord.
Or Mr. B.S. Tripathi, the counsel, appearing for the petitioner. Issue rule. Returnable on 21st of August 2023. You are appearing for all?
Yes. Yes,
Mr. M.K. Kuntia, an additional government advocate, appears and
I will appear for opposite part number 1, 2,
Yes,
there
one
is
for
a
private.
private opposite part.
what's notice for the opposite parties number 1.
Notice to go.
I'll take notice to.
Only one, I think.
Yes. I'll take notice, my lord, to opposite part number 2.
Why the state is not a major party? They are all employees of the state government working in the judicial department.
I'll make.
Respondent number 1, stop. The petitioner shall take steps for service of notice on the opposite party number 2. The Triparty London Council has assured that owing to inadvertence, the state has not been made party. He will take the corrective steps in the meanwhile. It's all right. Next.
Item 7.
Here, my lords, the petitioner has filed this applications on the as a public interest litigation applications, who is the president of the District Disabled Federation, Kalahandi. And he has questioned the very government circulars issued, my lord, in not granting or withdrawing the promotional benefit to the disabled persons, which is clearly violations of section 34(1) of the Persons with Disability Act. For lordship is convenient. Lordship, kindly just have the section which mandates, my lords. And that is also followed in different judgment of the Honorable Apex Courts, and even in recent 2 to 3 days back. Lordship, kindly just a glance. Section 34(1) of
Yes,
the PWD Act.
you go on.
That is 2016 Act. And I have also quoted
Why
para
this is a public
4.13.
interest litigation? No, first you convince why this is a public interest litigation. Why?
Because now we are the disabled persons. Now the government prohibits for giving promotion.
No, that is why they are the affected persons. They are the government employee. They can come straight to the court. Why it is a public interest
But
litigation?
that's for the lordships that say.
You have
can
to
give-
convince this.
Yes,
aspect.
yes, that I'm convinced.
Yes.
One, that in that respect, one judgment is there where the Honorable Apex Court in 2001 Supreme Court specifically stated that the Honorable Court in exercising power under 226 should be liberal in respect of the persons, those who are unable to come to the court, more particularly disabled persons But that judgment
He
is there.
can go to the workplace and cannot come to the court.
No, that disabled for that sake, I'm coming that another, because they are millers in the.
I can produce before you the two Supreme Court judgment where it says the public interest relievation regarding appointments, promotion, etc. should not be taken by the court.
Yes, absolutely. I do agree with that. That judgment is also there. I cannot say no, but that almost all.
And on the face of such judgment, how can we
I'm
entertain
so far
this?
service matters, that PIL is not maintainable.
Yes.
That law is there. But in some cases, particularly in 2001 Supreme Court, the Honorable Appeal Court says that when the persons are in a weaker section, particularly that the Honorable Court.
You are just taking up a case of the government employees. If
Yes,
they are termed as the weaker person of the society, maybe they are physically challenged, but they are differently able. They can come to the court. I think avoid on complications, file a fresh petition. Take back because it is their individual right. We are going to decide. We understand the children.
I do understand because I know so far the PIL service matter is not maintainable. As because they are the disabled and taking the advantage of the Honorable Appeal Court judgment.
Disabled, they are working.
No, they are working. No doubt that
We have acknowledged that they are differently able. That is why they have been employed.
Mr. Mahapatra, you have confined only to PWD employees. Had it been general, it is different. So it
No,
is
not
specific.
general. Only persons with disability.
Exactly. No,
Yes.
You just try to understand and complicate the matters. Withdraw. We are giving you the liberty to file a fresh. You file individual petitions.
All right.
Right.
disabilities in the PWD department. Person affected
Mr.
with disability in the
D.K.
PWD
Mahapatra,
department.
And the
Specifically.
threshold has submitted that you would like to withdraw this writ petition with liberty reserved to the person affected by the order dated 23/11/2022.
And 1773.
Comma, 17/7/2022,
20.
20 and 6/6/2023. The impugned orders in this writ petition. Liberty to challenge by filing a separate writ petition. Liberty of this writ petition stands withdrawn with liberty to the individuals who have been affected by those orders to file a fresh writ petition in this court. Accordingly, it is ordered. All right. I'm sorry, but Mr. Mahapatra, you have taken a good initiative, but they should come before us. Because it is their individual right.
I apprise my client that there is a difficulty
All right.
because you cannot come directly.
Thank you.
I
for
was not
cooperating.
applied.
All
Because
right.
he insisted 2001 Supreme Court. So all
All
right.
right.
No, your lordship says all right, the different judgments are there. Nobody can say no. And more particular law is settled. So for the service matter, PL is not maintained.
All
That
right.
I am fully aware of that facts. But because when they are
And one matter, the one High Court like Bombay High Court was severely criticized.
obviously. But I never, only one line I can offer lordship's convenient. Even in cases filed in public litigation, the court can exercise the writ jurisdiction at the instance of a third party only when it is shown that the legal wrong or legal injury or illegal burden is threatened and such persons or determined classes of persons is by the reasons of poverty, helplessness or disability or socially or economical disadvantages position unable to approach the courts for the relief.
They are not employed.
No, this is
They are
my
not
term.
employed. And this is the foundational principle of any public interest litigation. And that is the reason this is a doctrine of locus standi has been diluted for a special category of
Special
people.
category people, so obvious.
Yes.
Item 8.
Okay, your name is not being reflected. Just check up whether the Vagalatama is into record or not. Yes.
My lord, your honorable court directed to the petitioner deposit the outstanding demand amount of royalty on 69,94,857 and complying with the large requirement of the OMC Rule 2016 within a period of 3 months. So an extent of year 8 months and 10 days respect of the Khanjamal query 79 shall be granted to allow the petitioner to operate the query. My lord, the sympathetic ground, my lord, the present petitioner's elder brother, I have damage in 2 kidney, my lord. The transfer
This is you are now pressing this interlocutory application 1347 of 2022. What application? Because this main matter was disposed of.
Yes, my lord.
Right?
Yes.
So
Madam,
that,
only-
that you have to state, main matter was disposed of on 6/8/2021.
Yes, madam.
Thereafter, another order was passed in the disposed of case on 6/3/2023.
In last
Again,
order-
you have come.
Yes, madam. Last order, your lordship directed in 18/4/2023 to deposit the arrear amount, that is 69 lakhs 94,000 or so. So
Yes.
present situation of this present petition is, my lord, the elder brother's two kidney already damaged, my lord. Now treatment on the medical college, my lord. I have annexed all the documents. Transplantation of the kidneys, too much money is necessary. Now the petition is agreed to deposit 5 lakhs and some installment your lordship allowed. Then they allowed to operate the query, my lord.
Already you come to this order that was passed originally, this final order disposing the earlier writ petition. Where is that order?
Order I have annexed alert, my lord. Last.
6/8/2021.
Petition is allowed to operate the query, extend the period of without securing the.
Who is appearing, Mr. Muduli?
Already I have annexed, my lord.
Mr. Are you appearing? Earlier you appeared in this matter?
No, Mr. Naik was earlier appearing. My lord, may can see paragraph 2 of the order.
Original order, you were there. Thereafter, one
First
modification.
21, I was there.
Then one modification. Now this again, second modification. Only thing is there's a mistake in order. We
No.
should be disposed of the writ petition.
Only the.
My lord, may kindly see the order dated 18/4/2023.
I am not disputing the order, my lord.
Disposed
The
of
only
the-
ground is, my lord, that due to the medical transplantation of the kidney, my lord, I want some petition one time to deposit the sum of the amount and 5 lakhs instead of the 69 lakhs and thereafter some installment. Only this prayer I have modified.
This is just like putting
Nothing
the
else.
cart before the horse.
No, my lord, I have annexed all the medical documents, my lord.
Maybe.
You know, all those documents were of November 2020 or December 2020. And this final order disposing the writ petition was passed on 18/4/2023.
23.
We have disposed of writ petition twice. Once then and once again in April 2023 also we have disposed of again. Now you comes again.
Only, my lord, the
can
sympathy ground is it agreed to deport the 5 lakhs immediate, my lord. Then
Application.
some of the installment, my lord. For the transplantation of the kidneys, so much require, my lord, money. So kindly only sympathetic ground, nothing more, my lord. I have annexed all the medical documents, all the things.
No, it's all right. But Mr. Muduli, whether if he just submits a plan of making the payments in certain installments and one
No,
lump
he
sum.
can pay the installments, but he should not be allowed to operate prior to payment of the all
that
dues.
is the problem. No,
They allow the installment.
no, but you cannot operate. They say unless you paid this total amount.
That order is there. The order is there.
No, order in repression order.
What order we are proposing, that order is already there. After you deposit that amount of 69 lakhs.
94,856.
Comply within the period of 3 months, my lord. So
So
now
you will comply within 3 years.
No, no, my
what?
lord.
As per your plan?
my plan within 1 year, but
Like
now
you're saying 5 lakhs you will give.
now
After
immediate
69, why give 10,000 also is all right. You have to give a substantial amount. How can you give 5 lakhs and operate a quarry
no, no,
where the fees are 69 lakhs?
my lord, at least because due to the kidney transplant, my lord, that is the problem. No, otherwise, my lord, 5 years already that is closed, my lord, due to
Yes,
the
that
NGT.
is closed. Government is also losing revenue.
Due to the NGT direction, my lord, that is closed. Thereafter open, my lord.
Mr. Das, we are not a very good businessman, though we transact business every day.
Yes, madam.
But there is some other sources of this collecting the finance for making payment of this commercial deficit or the commercial liability. You approach any bank, commercial bank, they will provide you. Because we cannot shift our stand every now and then. That is very difficult. Because it is ultimately the national assets.
Yes, madam.
And
My
you
lord,
are
my lord, we will most of the pay the all royalty, my lord. But the only the condition is that your lordship consider otherwise nothing.
we are not going to change it because it's the second time that earlier also we have extended time. We've taken a flexible, but you have not. And then the next one pass the order. You are not appearing. Mr. Jena, I clearly now recall, was appearing. He says, only give us the 3 months time, we'll pay it off.
At least your lordship.
I think Mr. No, Mr. Naik was there at that point of time.
Yes.
Your lordship extension the time only 3-4 months or only arrange, my lord, whatever. Otherwise, we have no option, my lord.
No, this not consequences follow because it is the commercial matters. We cannot be that lenient because in both the ways it corrodes the value of the property. I'm sorry, Mr. Das, you'll come with a better case in future.
But your extension at least your lordship 3 months
That
after
this
the
source will be
deposit money.
put to auction, will get more revenue.
No, that is what. That is why I'm telling
My lord,
you.
Another
because-
thing is what Mr. Muduli is saying, it is correct.
Yes.
All these documents were there with you when the last order was passed.
Yes,
So
ma'am.
how many times you'll come up with different causes, different pleas we have
that is,
to. Na mane gona.
sudden that will come, my
Not
lord.
sudden.
Yes, ma'am.
This is 11/2022. Order has been passed in April 2023. When was the last order passed, Mr. Muduli?
18/4/2023.
23.
These
18/4.
documents are of 22.
So these are all known to you. I don't know. So you also understand that.
Another 3 months, your lordship.
Huh?
Another 3 months, your
Just a
lordship.
minute. Who is this Chakradhar Dhada?
Is my elder brother. Petitioner's
that
elder
is
brother.
the elder brother, not even the petitioner.
No, not in the petition.
Oh,
I have already mentioned, my lord, in paragraph 4.
that is correct. But that is why it didn't strike you that time. To
And
take this
exactly today, the 3 months granted by us expires.
Yeah, last
Today is
21.
the last day.
21, my lord.
So
Yesterday it expired. Yesterday it expired.
this, if you suppose we allow, considering what you are this contingency, 2 months more, and observing that no further time and
He should have shown his bona fideness. He could have paid.
No, I understand. We are very reluctantly saying the another 2 months granting, and then you take the action. We'll give this order in that way.
Since we have already given him something we can give so that if he wants, he can
Yes.
comply.
2 months you deposit or you'll be finished, I think.
Okay.
This is an application.
Within 2 installment. 2 months within 2 installment.
Whatever you feel, full the amount within
Yes.
2 months.
If you, it is up to you.
Yes, ma'am.
This IA number 10277.
By this time, you should have deposited something.
There's an application for modification of the order dated 18/4/2023 for extension of time to deposit the outstanding demand raised in relation to Khanja Mahal Stone Quarry number 76. Stop. By the order dated 18/4. (2023). First in this writ petition being WPC 22601 of 2021. We had clearly observed that the petitioner shall deposit the outstanding demand of rupees 69,094, sorry, 69,94,857 within a period of 3 months for enjoying the extension of 1 year, 8 months, 10 days in respect of the Khanja Mahal Query number 76. Today the today the time expires But Mr. S.K. Das, counsel appearing for the applicant, has stated before us, for various financial constraint, the writ petitioner applicant could not deposit any part of the said outstanding demand. Stop. Having considered all the circumstances, and also having heard Mr. P.K. Mudalil, an additional government advocate, we give a final extension of time by another 2 months. Stop. If within that time the writ petitioner cannot deposit the entire amount, the state will be at liberty to take appropriate action to take over the possession from the writ petitioner of the said query. Stop. The petitioner will not be in a position to challenge such action of taking possession in that event of failure. Stop. However, if the petitioner deposits the said outstanding within the extended period of 2 months, the remaining period of the lease has to be favored with the petitioner. In terms of our order dated 18/4/2023. Stop. In terms of the above, this application stands partly allowed. Stop. In our order dated, next line, in the paragraph. What is the order?
1840.
In our order dated 18/4/2023, inadvertently, certain observation has been typed and recorded. Stop. Instead of we quote unquote, we dispose of the interlocutory application, unquote. It has been typed as quote, we dispose of the writ petition, quote, unquote. Stop. We do hereunder correct the said inadvertent mistake. In the para 5 of the order dated 18/4/2023, in place of quote, we dispose of the writ petition, unquote. The following words as part of the sentence be substituted, colon, quote. We dispose of the interlocutory application. Stop. The registry is directed. No, by authority of this order, a necessary correction be made in the order dated 18/4/2023.
Obliged.
Once in 2 months from today. Okay. That will be fine.
Item 11.
Lordships, item 11, we see 2 weeks time for filing counter.
You are
Opposite
appearing-
party 1 and 2.
My lord, may I? My lord, I am for the petitioner, my lord.
Yes.
And I'm appearing. And this is only a rectification application, my lord. If your lordship kindly say IA number 16041 of 21. 5th of October 2021. And the last para, my lord, if your lordship kindly.
Order dated 6th of October.
No, 5th of October. 5th of October.
All right. What is
Order number 1. Last para, my lord, if your lordship kindly say. Last para. That is, as far as the interim prayer to allow the petitioner to live with the balance material of rupees 1,000. That is actually 10,000 metric ton. Rupees 1,000 metric ton of iron ore is concerned. Pendency of
Who is appearing for the state in this matter? You are appearing for the state.
I'm from opposite party 1 and 2.
Who is appearing for the state?
State, as per our report, no
Oh, no,
copy has
the
been
state is
sought.
not a party here.
State is not a party, I think.
So the Industrial Development Corporation, with whom you have entered into the lease,
with it call only. It call.
show us any document that the 10,000 metric ton has been reflected. Show us the document that you are permitted to just extract 10,000 metric ton.
My lord. My lord, in my application also I have said, my lord, this is an interim order passed by this honorable court. only.
Mr. Tripathi, we have understood it's an interim order, but please
Yes,
show us
madam.
some document that it is a typographical error.
Yes.
And another thing, it has been passed since 2021. You're not prejudiced by that order, I find.
No,
That
actually,
is pending
thereafter-
since 2003, 2 years.
My lord, I can, my lord, thereafter, my lord, Honorable Justice Mishra
This-
was transferred.
Anyway, show us, show us.
16049 of 2021.
I'm just checking. Point out from your writ petition, please.
Yes, my lord. Yes.
Because the NIT was for 30,000 metric ton.
My lord, for page 7,
Page 7.
para 8, para Roman 8.
Para 8.
This is 25,000. Further IDC tender number so and so. For
Where is
rupees-
the 10,000?
This is 25,000. I have taken the, my lord, the balance material only, 10,000 metric ton.
Where is
of
it?
this the balance material, my lord, it was document, if lordship kindly say.
Already the next state will correct it because she needs instruction also because it is a very important figure that we are going to correct. Let her say to take note of that in the first order that we passed on 5/10/2021.
Yes, sir.
There is a mistake is apparent because it says rupees 1,000 metric tons. It cannot be. According to him, it will not be 1,000. It will be the 10,000 metric ton. Right? You take the instruction. Huh?
Rupees.
Huh?
Then that mistake is obvious.
So there is a mistake we'll be going to correct in the next day. 15 days time is okay for you.
Rupees 1,000.
What is your good name?
Payal Roy, your lordships.
Payal Roy. At the request of you are on record.
Yes, your lordships.
Then
Miss
On
Pa-
behalf of Mr.
All right.
Durga Prasad Nanda, your lordship.
Why on behalf of? If you are on record, it's all right. Yes, you are on record. At the
Lordships
request
P.
of
Roy, Payal Roy.
yes, you are there. MSP Royal Learned Council appearing for the opposite parties number 1 and 2. Let the matter be listed on 10th of August. 10th of August 2023. In the meanwhile, the opposite parties number 1 and 2 shall invariably file their counter affidavit. Else no accommodation will be made. Stop. In I number 16041 of 2022, no? This is an application for correction. According to Mr. No, there is there we have to modify this commercial. Okay. Mr. Dr. K.N. Tripathi, Learned Counsel appearing to the applicant has stated that in the order dated 5/10/2021, and a mistake has crept into the order in the second line from the bottom, where it has been typed at rupees 1,000 metric tons of iron ore instead of 10,000 metric tons of iron ore. Stop. We would request Ms. P. Royal and Counsel, who is appearing for the opposite parties number 1 and 2, to take instructions from the opposite parties number 1 and 2 in respect of the said mistake. All right.
Both of you check up. In the earlier IA in the prayer, the 10,000 metric tons is written. All right.
Yes, Your
Item 12.
Item 12, my lord. Earlier, this matter has been a notice issued and status quo has been amended, but
You just come closer to the microphone.
Not be issued due to late filing.
item 12, my lord. Earlier, this matter has been earlier this matter has been taken and notice has been issued and a status quo maintained, my lord. But unfortunately,
You could not file the requisite within the time stipulated by
my
the
lord, I have
court.
filed already,
All
but
right.
some delay is there. That's why,
Already, you are Mr. Roy.
my lord.
At the request of Mr. A.P. Royal and Counsel appearing to the appellant. No, Mr. A.P. Royal and Counsel to the appellant has stated that the requisites could not be deposited within time is fixed by this court. Stop. When the requisites are tendered in the registry, belatedly, registry did not accept those requisites. Stop. We direct the registry to accept the requisite and issue notice.
OP5, my lord.
As per order, the issue notice as per the order dated 17/5/2022, 2023, showing the returnable date on 28th of August 2023.
My lord. Objection. My lord, that status quo will be continued till that.
The order we
Yes.
completed. Wait.
20
If I may please, your lordship, I am appearing in
more than 1 month, 28th of August.
I'm appearing in writ appeal number 3 of 2023, your lordship.
That is connected.
Connected rate, your lordship. Connected matter.
All right.
The requisites, your lordship, unfortunately has not been filed. I pray for some more time, your lordship.
You have not filed.
No, your lordship. As per the noting, it has not been.
Just
No, not as per the noting. Actually, have you filed or not?
I don't have the receipt also, your lordship.
No, have you
No.
filed or not?
I-
Yes or no?
I'm not aware, your lordship.
Not aware.
Yes, your lordship.
Then why have you come?
Lordship,
in the
Are you
matter,
What is this casual submission? I can't understand.
lordship, I
that
don't
is
have
a
the receipt
requisite,
to
I
even
think,
verify
for
this.
the private respondent number 5 only, no?
Yes,
The
your lordship.
requisite, your
That is
requisite
mine,
for 5.
mine.
That is
They
the
could not
first
file
one.
requisite, there's a requisite for serving notice on the
What is this one?
respondent number 5, that you just make it that way. Returnable date, Mr. D.K. Mohanty, learned additional government advocate, has appeared for the respondents number 1 to 4, 1302, 24. Yeah, this is, in your matter, you have not filed the requisite yet.
No, lordship.
WA3. You are Mr. Sahu.
No, your lordship. I'm appearing on behalf of my learned senior, Mr. Bhuiya, your lordship.
What is your good name?
Saurabh Suman Bhuiya.
Mr. S.S. Bhuiya, learned counsel, appearing on instruction of Mr. B. Bhuiya, learned counsel, has stated that the requisite could not be filed by the appellant. And as such, some more time is required to take appropriate steps in terms of the order dated 10/4/2023. Can you file today itself?
Your lordship,
By
I'll
tomorrow?
file it by tomorrow.
So we direct the appellant to file the requisite for serving notice on the respondent number 4 by tomorrow by speed post, the register post to 880. So if such steps are not taken, next step, the appropriate order for non-prosecution, the order for non-prosecution will be passed by this court. Mr. D.K. Mohanty, learned additional government advocate, appears for opposite parties number 1, 2, and 3.
Here, Char.
All right.
Item 13.
Much obliged, Your Lordship.
My lord, this matter posted for 28th August.
Very difficult. 20 in this month, posting is very difficult because
No, he's asking when you think that matter.
28th of August.
Oh,
You are appearing in this matter.
yes, yes, my lord.
In
He is in another matter that which that is
What is it?
retable 3 of
2023.
all right. There is a disposed of case. There is in which matter you are appearing.
Your Lordship, the writ appeal arises out of that disposed case.
No, that in WA3 you are not appearing, I think.
no. I am appearing in 672 of 22. Top of that on a 12 item 12 first matter. Retapil 672 of 22.
But only 2 matters are under this item number 12, this writ appeal number 672 of 2022 and writ appeal number 3 of 2023.
Identical matter. I am in retapil 672 of 22. He is in retapil 3 of 23.
Where is the 6 has not been listed today?
My lord?
6 writ appeal now 672. Oh, yeah. All right. You are
Identical
appealing
matter.
for whom?
Identical matter, my lord.
Oh, I have already passed the order. I have recorded
cases.
your name.
In
I
both the
thought
cases,
another
your
matter
lordship
is
has
there,
already
no?
passed on.
Much obliged.
Next.
Yes.
My lord, I may be pardoned at item 13, my lord. My friend is on his legs, my. May I permit to put the IA, my lord.
Delay.
There is a delay of 25 days only. But the registry has showed 183 days. That order was passed on 23/9/2022. They supposed to file within 1 month. But due to medical certificate he has given, and as soon after recover, there is 25 days
Your
delay.
registry has rightly counted. Because these are the causes now you are assigning. This calculation is not wrong.
He has given the certificate that
For obtaining certified copy, you consumed additional 2 days that has been deducted from the delay.
but he has not filed the original certified copy. He has obtained a Xerox copy has been filed at the time of filing.
What is the rule says that your appeal will be only complete when it is filed with the certified copy?
But kindly urgent after lunch, I have not certified copy. He is on the expert.
We understand that.
My
Are you opposing the prayer?
Because he has not filed the certified copy, that is why delay.
No, they're admitting that there is a delay of 183 days. He's produced some medical certificates and other thing.
Dispose of the condonation section 5 application.
That we can condone.
Yes.
And we take up the matter on merit on the
Merit.
No.
Yes, I am ready for the merit because.
Are you ready for the appeal to be heard on merit?
Keep it after lunch, my friend.
After lunch?
After lunch, why?
Okay, have a sumptuous lunch and come
But
back
only
to us.
provided with the I and not the
All
original
right,
file. Just
all right, that too, it will be taken up. Come.
My lord, there is a municipality has to be noticed. There is opposite part number 3. Respond.
No, that admission notice will issue because I don't
Only for the purpose of admission.
Come at 2. Or the municipality has a standing council, Mr.
No, the Sambalpur municipality, I don't know where they.
Sambalpur doesn't
standing
have,
council.
okay. All right. Come at 2.
I learned. After lunch.
After lunch. What is the next?
Item 14.
In item 13, my lord, there is 87 days delay. My
Notice has
lord,
not been
senior has
issued.
appeared. If the
Notice
delay,
has been issued. Notice has been issued.
no, my lord, senior has appeared in this case. If delay can be.
What I suggest, if you actually look to the impugned judgment, a batch of cases have been disposed of by a common judgment. And different counsels had appeared, though I was arguing. So if all the matter, if they have preferred an appeal or not in separate appeal, I don't know.
Cases were prepared.
So all the matter will be listed so that you also can hear both
All the
litigation as well as
filed, all the
the-
appeals.
Yes, my lord.
So you ask all the matters, you give a list of the number. We list all the matters together.
Yes.
Day after tomorrow.
Yes, sir.
Mr. M.K. Kuntial and additional government advocate appearing with the appellant has submitted that from the common judgment, there are several appeals by the state of Orissa, by the state of Orissa are pending in this court. We would request Mr. Kuntial to give a list of those cases by 4 today. 4 p.m. today. So list is directed to list all the matters day after tomorrow.
Beg pardon, my lord.
You have appeared.
Sorry. Beg pardon, my lord. My lord, in the first case, my lord, my learned senior friend says that they have preferred appeal in each of these cases where that common judgment has been passed by single order. But fact remains, since in my case was also disposed of in that common judgment. Since in my case, no writ appeal has been preferred yet. I had to intervene and I had filed an intervention application.
No, everything will be taken when the mace case will be taken.
He says that he has filed already.
Filed.
So your lordship,
In the
It will
meantime,
come to day after tomorrow. You'll be there.
Can it be taken up next week, next Monday? In place of day after tomorrow?
Give a date. But no problem, forget to give a date on next date. It will come on 25th. If there is another matter in view of the order first, list this matter on such and such date.
15.
My condonation petitions filed later. My condonation petitions has been filed later than the writ appeal that was before your lordship today for consideration. And there are certain defects also which unfortunately I have not found out. I have not seen.
It is item 15. Because private party is there. We cannot condone according to the law without issuing notice. So we are issuing notice because private individual is there, otherwise we could have passed the order. Heard Mr. T. Patnaik, Learned Counsel, appearing for the applicant. This is in I number 4069 of 2023. This is an application under section 5 of the Limitation Act for condoning the delay of one day in filing the intercourt appeal from the judgment from the order dated 24/1/2023 delivered in WPC number 2399 of 2022 by the learned single judge. So issue notice as to why the aforementioned delay should not be condoned or any other order or order shall not be passed. Notice is made returnable on 28th of August 2023. Since Mr. M.K. Kuntial, an additional government advocate, appears and waves notice for the opposite parties number 2, 3, and 2 and no, opposite party number 2. No formal notice is called for in respect of that opposite party, but the applicant shall take steps for service of notice from the remaining respondent by registered post with ID within 3 days from today.
The second matter 381.
Meanwhile, the defects
The same
identified
arises out of
shall
the-
also be removed.
Yes.
Have you received a copy?
Yes, well, I have received a copy.
Okay.
The second matter, which is there also of the same judge,
1 day delay.
arises out of the same judge.
In the second matter, just below that is a 1 days in place of make it 3 days.
No, delays, the second matter delays 4 days, my lords.
4 days. No, according to our calculation, it is 3 days. We are reflecting 3 days.
My lords. Oh, bless my lords.
Here also, opposite party number 2, Mr. Kuntia. Yes. Defect be removed. Just replicate the order, making these changes. Huh?
Item 16.
Yes, my lord, here, the present appeal arises out of an order passed by the Honorable Single Judge my lord, on yes,
So it is from
17/4/2023. Whereas, my lord, the opposite party was also agreed having a compromise. There was a compromise arrived between the parties pursuant to the order passed by the Honorable Court. Basing on that compromise, though they have violated the order passed earlier, passed by the Honorable Court, that the Honorable Court directed the unless and until there is a compromise, the status quo over the shootland to be continued. But during the status quo period, they have also installed a boring point over that disputed plot. Thereafter, when I have filed a contempt petition, my lord, they also arrived directed me that you to come and have a compromise. And when the contempt petition was pending before this Honorable Court, they have stated that there is a compromise. You are ready for a compromise. Yes, the petitioner also agree for a compromise. Basing on the compromise, they said no. Once the that boring well has been installed, it cannot be removed. So only the other part, that is that compound wall and the storage of water, that should be installed. That should be constructed after the 25 meters away from the main point. But despite that also, they have not carry out the order passed by this Honorable
Come
Court.
to the paragraph 12 of the impugned order.
Sir. Yes. In view of the above, this court is of the consider opinion that the prayer of the petitioner to shift the boring from the original point 25 meters distance over 440 is not sustainable, as it has already been agreed upon by the parties that since the borewell has already been sunk by the time the earlier petition was filed, it could not be shifted. It is a wrong statement. What happened, my lord? The boring point was also installed. There the order passed by the Honorable Court. When the Honorable Court also directed the opposite party that
you show us how it is unsustainable.
My lord.
Do you agree there was an agreement to
Yes,
just...
yes, please. I have stated everything, sir. Sir, I have para 3. Page 3, sorry. Page 3. Page 3, sir.
Page 3 of what?
Page 3, I have quoted the order.
In your appeal?
Page 3, para 2, sir. Para 2, sir.
In your appeal or in a writ petition?
Yes, yes. I have quoted the order, sir. The petitioner already approached this Honorable Court. Page 3 in the appeal. Yes, appeal memo.
Right.
The petitioner already approaches this Honorable Court against the action of the opposite party. The construction of the boring point, the writ petition was disposed of on 22/9/2021 with observation given below. The observation is regarding hard
to the facts and submissions and the nature of the relief sought for, and without going into the merit of the case, the writ petition is disposed of, directing the Assistant Executive Engineer RWS and S Nimapada, opposite party number 5, to dispose of the representation of the petitioner via Annexure 5 series within a period of 3 months from the date of receipt of the certified copy of this order, be passing a rigid order taking into consideration the plight to be suffered by the petitioners. The petitioners are directed to supply the copy of the writ petition containing all the annexures to the opposite party number 5 along with the certified copy of this order for convenience and the
This is
reference
just
to
can see, this is not at all relevant. The
Sir,
context that I am showing in the
No,
paragraph
that is
12 comes
relevant.
straight to that part where this.
Yes, sir, that is how it is relevant. It starts from here. This till disposal of the representation, this is important. Parties shall maintain status quo as on date over the spot in question. Thereafter, what they have done, since the opposite party violated the order passed in WPC number so and so,
yes.
Content petition 7138 of 21 was filed. In the said contempt petition, so was filed dated 16th December 2020 by the alleged contemptor, filed by the Assistant Executive Engineer RWS and S Nimapada, in which I have quoted what was the complaint. That in reply to the amendment made in the para 4 of the contempt petition, it is humbly submitted that the deponent never violated the order passed by the Honorable High Court in any manner. Moreover, status quo has been maintained over the plot in question since 2/9/21 had no further work related to the pipe water supply to the Dhamantera has been taken up over the plot in question under legal process. After received the order dated 22/9/21, the Honorable High Court passed WPC number 29408 of 21 that in reply to the amendment made in para 6, the contempt petition, it is humbly submitted that the deponent has not started any work except the borewell. The borewell is the main question. Except the borewell, they have violated the status quo. Sir, sir, earlier there was a status quo order, they have flouted the status.
No, what is this observation? That
Sir,
is
sir.
humbly submitted that the deponent, para 6 of the contempt petition,
Sir.
has not started any work except the borewell.
Borewell,
over
they
the
have
plot in question.
Sir, when there was a status order, the entire plot was remain open. But they have flouted the order passed by the Honorable Court to started a borewell there without any compromise, without anything. Thereafter, as alleged in their presentation beyond 22nd September 2020, as per the order passed by the Honorable High Court, and status quo has been maintained without any violation, they have stated. My Lord, thereafter, that in reply to the amendment made in the para 7 of the contempt petition, it is humbly submitted that the work has been taken up for sinking of the production well only after the site selected by the local representatives and the villagers concerned. The development work for the providing drinking water to the local people of the village Dhamantera has been taken up on the priority basis with the cooperation of the local inhabitants as for the selected site. Moreover, the present humbly prayed before the Honorable Court to consider the amendments made in the foregoing paragraphs and dispose of the case on the ground of public interest and drinking water is essentially required for the general public at large. Sir, then that pursuant to the order 11/1/2022 in the said contempt, the compliance affidavit was also filed by the Assistant Executive Engineer at RWS and S Nimapada on 27 January 2022. Relevant portion of the which reads as follows: that it is humbly submitted that the petitioner were invited. There was a compromise when the contempt petition has been dropped basing on they have agreed for a compromise. Contempt petition also dropped. But what was it? That it is humbly submitted that the petitioners were invited to attend the meeting on 21/12/2021 at office of the Assistant Executive Engineer RWSS Subdivision Nimapada towards hearing of their grievances and the disposing the same by letter number 2116 dated 14/12/2021. Xerox copy letter 21 dated 14/12/2000 is filed herewith as Annexure D. But the petitioners expressed their inability to attend the meeting scheduled to be held on 21/12/2021 and a request to reschedule the date. As per the request of the petitioners, they were also re-invited to attend the meeting on 28/12/2021 by letter number 2166 dated 18/12/2021. On 28/12/2021, the petitioners attended the meeting held at the office of the Assistant Executive Engineer RWSS Subdivision Nimapada and fruitful discussion have been made and unanimously decision has been taken of to resolve the grievance and to dispose of the cases, and the opposite party assured not to take off any further work regarding the construction of elevated storage reservoir. That is they have also evaluated the elevated storage reservoir pump house of pipe water supply of Dhamantira Nimapada block over the plot number 497 to the government land. The opposite party further assured to take steps to reselect the site towards shifting the plot number 440 by requesting the villagers and the PRI members only underground pipe connections may be done with the production well which has already been sunk. That was the underground pipelines, they have no change. Only change is the elevator, the water service may be done with the production well which has already been sunk. Xerox copy of the proceeding of the meeting held on 28/12/2021 is filed herewith as Annexure E. That it is humbly submitted that the present deponent has also intimated regarding the proceeding of meeting 28/12/2021 to the Executive Engineer RWSS Division Puri, vide letter number 93 dated 10/1/2022, and also the requested the Tahsildar Nimapada, vide letter number 47 dated 5/1/2022 to alienate the land for the pipe water supply Dhamantira village under the Nimapada block. Xerox copy so and so dated 10/1/2022, letter number 47 dated 5/1/2020 is filed herewith Annexure F and Annexure. Considering the compliance affidavit filed this court by dated 29th April 2022 to drop the contempt proceeding. My lord, it is pertinent to mention here that supply of the water from the boring point to the field will be through the underground pipeline. We don't have any objection. But the transformer for the power supply will be inside the government plant. Thus, we will not be difficulties for the petitioner to approach his agriculture. He also referred to the settlement of the arrive between the parties relevant portion. The opposite party, this is the compromise arrived between the parties. The extent is with me. The opposite party assured not to take off any further work like construction of ESRI pump. That is ESRI pump. How it is as PWS to Dhamantira over the plot number 497, as every steps has been followed to maintain the status quo. Further, the petitioner have requested to shift the site from plot number 497 to plot number 440 in Khata number 218, approximately 25 meters away from the production well already sunk for better convenience. But they have violated the same. Instead of 25 meters, they have only distance of 12 meters. That was it. We have agreed on the compromise basis. We have agreed because this is for the public purpose. They sunk. They have not flouted the order passed by the Honorable Court. But despite that, only that water storage should be shifted to the 25 meters away from the main point.
Yes.
They have violated once they have agreed in the court, but done something else.
But what is the paragraph 12? Read paragraph 12.
Yes, sir. Paragraph 12. Paragraph in view of the above, this court is consider opinion that the prayer for the petitioner to shift the boring from original point 25 meter distance over 440 is not sustainable. How it is not sustainable? It is not sustainable. Basing on the compromise, they have agreed.
You yourself agreed this is the
we have agreed for that 25 meters away from the main point, but they have not done.
No, you have agreed the bore will be maintained in the same place where it
yes,
is.
We have agreed because for the public purpose. Only this water storage, the water storage should be shifted 25 meters away. That was agreed by the opposite party. They have agreed. They have agreed. And my lord, the honorable judge says the 25 meters and so and so is not sustainable. Then what is the purpose of getting an order? What is the purpose of passing an order? Because the contempt proceeding has been dropped.
No, we also do not understand why this kind of a dispute should be at all entertained in a writ proceeding. You take the intervention of the village panchayat, you are coming to the courts, wasting the important time of the court on the when the boring will be done in a particular field or not. Is this for the constitutional courts are constructed?
No, my lord. How this is that was a government product because by installing a boring point. That was also obstructed to take use of my field, my agricultural field.
That is absolutely, you have remedies. If you don't like to give, don't allow them to give. You are agreeing and coming to the court. No, this is
Sir,
not the.
we are not agree, sir. Why you are agree? When they are flouted
We
the
are
order.
not here to dispute this individual interest and disputes. You are taking a government project, it should be on your.
A government project, we are agree also, sir. We are agree.
All right.
They are also agree. They took.
Who is appearing for the state? You are appearing for the
Yes,
state.
my lord. It is on the government land, but their problem is their private land is being allegedly obstructed.
But that matter has already been settled with
That
the
is
compromise
settled,
because they have
I don't know.
agreed on a compromise
Before
when the
the on-
contemplation has been dropped.
If
Now
you-
taking a different stand.
If your lordship will go through the.
Just you take your seat
Sir,
when
sir,
we are interacting with
Yes,
other
sorry,
council.
sorry, sir.
If your lordship will go through the impugned order, during pendency of the writ petition, several endeavor was made for an amicable settlement. There was a compromise and he agreed for it. And thereafter he is saying that this is not acceptable, that is not permissible, and you cannot sunk here, you cannot put your. These are all the things subsequently developed things. And that is why the Honorable Court said that matter should be, because we are constructing over our land. It's not a case of land acquisition or something like that. And it is for the public purpose. It will also help his agricultural.
You are obstructing me. I cannot take use my agricultural land. For that reason, I come to the court.
I cannot follow your submission.
Sir.
He says the entire bore well has been sunk in the government well and they will complete the project in the government land.
Government land, that dispute has already been over, considering that the status order was also passed by this honorable court. Because by installing that bore well, that has been created obstruction that I could not take use of my agricultural land. For that reason, I came to the court.
No, what you cannot take to your agricultural land?
Because that has been obstructed. Because my the very plot is also adjacent to my plot, my private plot. So once there is a bore well, I could not take use of I could not take my tractor to my field. I could not enter into my field. For that reason, I came to the court. So honorable court also directed. Later representation will dispose of till and status to continue. Status was during the status quo period, they have flouted the order. They say because of public interest, we have sunk that well. All right, we have sunk you sunk the well, but I adjusted because there was a meeting, the settlement was there. But when you have agreed in a settlement, contempt proceeding has been dropped. But again, you agree, yes, I can also construct that storage compound wall 25 meters away from the main point. But why again you have also flouted not now in the 12 meters?
Have you constructed this storage?
That is not also.
That is
the dispute.
That is constructed. He is saying that not 25 meters, it is 12 meters.
That was agreed by you in compromise.
But where is that compromise? That is not.
I have read that compromise. Where is that?
12 meters. Everywhere it is 25 meters.
25 meters you have agreed, but now you have constructed within 12
right.
meters. That is the point.
Where is that material that we are constructing 12 meters? Or
you take instruction. You take instruction.
Because that was the subject matter of the contempt, and contempt was dropped.
Contempt was dropped because you have come forward for compromise. That for that reason contempt was dropped. Once there is a compromise, court says you arrived at compromise between the parties.
And we are doing over our government.
Everywhere government land, everywhere is government land.
So why your executive engineer to come to the page 4 of the memorandum of appeal?
Page 4. Yes, madam.
First of all, it is your reply.
Yes.
Counter affidavit.
Yes, my lord. That in
Para 9.
Para 3.
Para 3, 9.
9.
That in reply to the arguments made in paragraph 4, the contempt petition, it is humbly submitted that the deponent never violated the order passed by the Honorable High Court in any manner. Moreover, status quo has been maintained over the plot in question since 22/9/2021. Had no further work related to the pipe water supply to the Dhamantira has been taken up over the plot in question under the legal process after receipt of the order dated 22/9/2021 of the Honorable High Court, passed WPC number 29408 of 21. That in reply to the averment made in para 6 of the contempt petition, it is submitted that the deponent has not started any work except borewell over the plot in question, as alleged in their representation beyond 22nd September 2021, as per the order passed by the Honorable High Court, and the status quo has been maintained without any violation. That in reply to the averment made in para 7 of the contempt petition, it is humbly submitted that the work has been taken off for sinking of the production well only after the site selected by the local representatives and the village concerned. The development work for the providing drinking water to the local people of the village Dhamantira has been taken off on priority basis with the cooperation of the local inhabitants as per the selected site. Moreover, the present Hon'Ble prayed before the Honorable Court to consider the amendment made in the foregoing paragraphs and dispose of the case on the ground of public interest as drinking water is essential.
Mr. Mohanty, just come to the page 8.
8.
And read from the line, the transformer for power supply
Sir.
will be inside the government plot number 440.
Sir.
Page 8, para 5.
Para 5.
Para 5.
Yes.
It is pertinent to mention the supply of water from the boring point to the field will be through underground pipelines. The transformer for power supply will be inside the government plot.
Yes.
Thus, there will be no difficulty for the petitioner to approach his agricultural field. He also refers to the settlement arrived at between the parties, relevant person of which rates has thus. So there is no difficulty to.
No. Yes, that is difficulty. No difficulty for pipeline. You have inside the taken the pipeline.
No, his
inside.
demand is also you shift it to the plot number 440.
Yes, my lord.
So that you have agreed that you will shift it to the 440.
And but how now he is saying that we have deviated this particular.
No, nothing. Forget about it. Can you shift this to the 440, the storage system?
That right now I cannot say because I have to get instruction. But only thing I want to submit for where he has alleged that instead of 25 meters, we are constructing 12 meters away from the board point. There is no allegation in the
Yes, that is special allegation. That is stated in special allegation.
In which para you saw?
You see, read the impugned order.
No. In appeal memo, where you have
appeal memo
taken
arises
this
out
ground.
of the writ petition.
You
The
have
appeal
not-
arises out of the writ petition.
You have not taken this ground.
That
in
is the
appeal
ground.
memo.
That is the ground in the
Where?
impugned order.
Which ground?
You read
You
the
placed there.
impugned
No,
order. Please
why
read
should
the-
I read?
No.
You placed the ground.
That
You
is
are the appellant.
That is the impugned order.
Your lordship may see this.
Para 11.
Now
Please.
he is
Page
placing a
23.
new controversy.
No new. That is
It's only a
totally
new
what-
controversy.
The shifting of the construction
just,
plot
just
440,
we are- just we are-
25 meters away. Sir.
Mr. Panda, please
sir,
take
sorry.
your seat.
Sorry, sir. Sorry.
Please.
He will not allow us to say
anything.
Please sit.
Sir.
Take your seat.
Sir.
Mr. Mohanty, that it appears that you have made an assurance that you'll shift to this plot number from plot number 497 to plot number 406, the storage, not the borewell.
Not the boring point.
Borewell will be there in the same
Yes.
place.
Wall, that wall.
For which there is for I think the pump for setting up the pump.
Yes.
That. So this is your clear this acceptance in the meeting.
No, that is there. What your lordship is saying, that is there. Now his allegation is that instead of 25 meters, 12 meters we are doing. That is what I gathered from the argument of my learned friend. But that is not stated in the appeal ground.
We are not going into all these matters.
Yes, my lord.
Say you construct on the plot number 440, so that his entry to the land is not restricted that much.
I will take instruction on that. Or what is the status, real status? Only I will take instruction. No,
Take instruction, particularly what you have agreed in the paragraph 5 of this memorandum.
in that light, your lordship may pass an order. I will take specific instruction.
All right. We have heard Mr. N. Pandal and counsel for the appellant for quite at length, sorry, not quite. So Mr. Panda has pointed out that the opposite parties had agreed to shift the storage and construction for the pump to plot number 440 from the plot number 494. Stop. It appears from the para 5. There is a site plan of shifting this part of the plan of shifting the site partly was approved by the government officers who were having discussion with the villages, including the petitioner. Stop. Mr. D.K. Mohanty, learned additional government advocate, has submitted that offhand he cannot make any submission. He is to take the instruction about the status of the project. Let the matter be listed on 3rd of August, 2023. Appellant and respondents.
Obliged.
You find out the solution, and this matter usually court should not have taken.
Sir.
We cannot go to the field. How it is abstracted? It is a civil
Firstly,
court
it
matter,
cannot
so
be
you
a
want to go.
PIL. I'm sorry, it is arising out of a single bench decision, but these are all developmental projects. And he is saying that my land is
You agree
obstructed.
one way, you can disagree. Agree one way, you agree compromise was there. Basing on compromise, you agree, you can also fulfill your agreement.
Already we passed the order.
Sir.
And nobody will pay you any fees for this submission you made right now. But after passing of the order, these submissions are completely irrelevant. Okay.
17.
May I please, my lord. My lord, there is limitation. Now here, in fact, the judgment was delivered on 21/4/2023, and the appeal was filed on 22/5. My lord, however, instead of filing the certified copy, the Xerox copy was filed, and that is how the Xerox, subsequently the certified copy was filed on 28/6. And that is how the delay has been shown, my lord, which is because of this error of not filing the certified copy and filing the Xerox copy of the certified copy.
No,
So
according to the rule, they are correct.
I'm not my lord, submitting that the office was error in pointing out the limitation. I'm only
Anyway,
simply
Ms.
submitting.
Patnaik will not oppose your prayer, I believe.
My
37 days delay.
no, that is a bona fide error this way. So that is what I wanted to point
37
out.
days and 30 days because the certified copy
Certified
was
copy.
not filed. Already condoning the delay. IA number 4050 of 2023. Or Mr. S.K. Mistral and his senior counsel,
I know 260, no?
ested by Mr.
260.
Jagajeevan Pradhan, right?
Mad.
And counsel for the applicant. There's an application for condonation of under section 5 of the Limitation Act for condoning the delay of 37 days in filing the appeal, intercourt appeal against the order dated 21/4/2023 delivered in WPC number 677 of 2023 by the learned single judge. Stop. MSS Patnaik, an additional government advocate, appearing for the opposite parties, says that the threshold submitted that these opposite parties will not oppose the prayer for condonation, considering the length of delay. Stop. That apart, we have perused the causes assigned in this application, which according to us satisfy the requirement of sufficient causes. According the delay stands condoned, in the result, this application is allowed in this post of. In view of the order passed today in such and such, leaves this appeal for admission on. Give a date.
I was praying, subject to your lordship's kind consideration, for a short date, because my lord,
On
the order has
25th.
been passed beyond assignment vis-a-vis the prayer made in the writ petition.
25th of July. Come on 25th of July.
There was a little confusion, my lord. Let my senior clarify it. I have an IA number 260.
No, you
Whether
have
that is there, no, whether that is there in lordship's.
No,
record,
let
that
me
I
just
wanted
humbly
to-
clarify. The IA number is 4050. Possibly the copy that was given to my learned friend, the IA number was put erroneously.
that
But
is- I just
after I
wanted to
filed the
clarify.
slip in the morning,
No, we are
the
seeing from the record.
4050.
Yes.
4050. Okay.
I'm conscious of that because
No, I just wanted to clarify because I didn't know what IA is there before a lordship.
Okay.
it is the same IA which my friend is holding, except that
But
the
the
number.
number was
Nice. Obliged.
25.
25.
2023.
There are two matters in the special list. All these two matters have been filed by the state. My lord, since it has been mentioned by my learned friend, so it was specifically urgent, but it was not listed. So may I pray, Lordship, may call this matter on 20th, day after tomorrow at 2 p.m. can be disposed.
Day after tomorrow, 2 p.m. There is no sitting of this bench. There will be this commercial appellate bench.
Tomorrow, let's say tomorrow.
Tomorrow also.
Tomorrow.
Huh?
Tomorrow onwards.
Tomorrow also the same problem will be there.
Because they're contractual employees, Lordship.
One thing can be done that all the councils will come from outside. 7 days, not together. Is there any urgency in the matter, Mr. Devi?
Lordship.
Any urgency?
Urgency, Lord, both the petitioner respondents are contractual employees of the Gram Panchayat. They were disengaged since last 2 years, Lordship. And Lordship, the order of decision has been quashed. And on similar footing, in fact, Lordship taken up more than 40 matters. They have allowed more than 38 candidates. And they have come up both the matters in writ appeal. And relying upon a subsequent judgment, they have obtained stay order, Lordship. We are out of employment and our livelihood is take, Lordship. That's why I had mentioned a Lordship fixed to 2 o'clock today, Lordship.
No, I understand. Because we plan to fix the matter on 3rd of August for disposal. Right?
Lordship, as Lordship.
3rd of August.
At 2 p.m.
Fourth matter, fourth. It is better will be fourth.
Fourth, Lordship. Fourth is a Friday, Lordship. Friday usually.
It's 1st of August.
1st of August.
Oh, second. Oh. Third fix on third, let us see. Third. We are fixing on third.
First.
3rd of August. As agreed by the council for the parties. That this matter be listed on 3rd of August, 3rd August 2023. There shall be an attempt to hear the matter at this stage, considering the urgency it is to the subject matter. Mr. P.K. Mudoli, learned traditional government advocate, is appeared for the appellant, and Mr. S.K. Dolui, counsel, is appeared for the respondent number 1.
Lordship.
In both the matters?
Both the matters, Lordship. Both the matters I am
Interim order is there.
Same order.
In both the matters, interim orders.
Interim orders passed, shall continue till the next stage. Okay. This is the matters.
It's at 2 o'clock. 2 o'clock.
Not 2 o'clock. We are
2
fixing
o'clock,
it.
yes.
Already at 2 o'clock.
Grateful, Lordship.
2 p.m. But meaningless that we have done. Yes.
Item 55.
55 are pursuant to my lord's order. Today I am filing the reply to resender affidavit.
Oh, sorry.
Today you are filing.
Yes.
But order was very clear that you filed before the date.
It was filed by e-filing. Yesterday it was e-filing. I'm sorry.
You have also not supplied a copy also. The matter is called out, Mr. Mudali. It's 55.
I have supplied the hard copy of the.
Is it possible for you to make submissions today?
My lord.
Is it possible for you to make it submission today?
But both.
Then we just defer the matter.
But I have, unless it will be difficult.
No, difficult. Obviously, I understand.
In fact,
Make it on 25th. We are fixing on 25th. Mr. Muduli, this is not fair. You are supposed to file much earlier so that he can prepare. That was the order.
Yesterday evening, I felt I could not find him, so I could not solve.
It's all right, but this is not done. You usually do not do this. That is why I'm just pointing out. Mr. P.K. Muduli, non-additional government advocate, appearing for the respondents, has filed the additional affidavit in response to the rejoinder filed by the petitioner. So the said affidavit is taken on record. Mr. L.K. Maharana, and counsel appearing for the petitioner, has prayed for a very short accommodation to go through the said affidavit. So, with the prayer tense allowed, let the matter be listed on 25th July 2023 at 2. It's not possible. July, it will not at 2 possible because there is a special bench at 2. So you just come on the first part only.
in the 10:30. Make a mention on that day.
Mention, but at 2 there is a special bench will be there. For spearing a matter as per that. Mention that we will try to upgrade, but we'll see because it will be on list.
Then if I make a request, if your lordship
right,
keeps it through.
Right. Yes, call them regular matters.
Item 62.
Item 62, you also kindly look to your lordship's order dated 10/7/2023 or in writ appeal number 1260 of 2022. The connected has to be same. Also look, I think in the past case also you also past orders. 10/7/2022.
Josnamui Behera versus State of Orissa.
Yes, sir. Because you have directed the state to file an affidavit. They have filed an affidavit pursuant to your lordship's order. I'm just recapitulating your lordship's memory. Way back in 2014, an advertisement was made. Date chart I've already placed, and your lordship heard these matters.
Yes.
So out of 10 vacancies, in fact, 7 joined and 3 vacancies, 3 posts are there. The lordship wanted to know, and 7 persons are continuing from 2014. You also kindly look to your lordship's order. Heard the applicant at length.
Yes. You are referring to which order?
Your order dated 10/7/2023.
Yes, yes.
Sure. Can I upload it? Also look to that 10/7/2020.
Yes.
Last order after hearing.
Yes, I got it. Yeah.
Yes, sir. Heard the applicant at length, but at the request of Mr. Muduli, an additional government advocate who is appearing for the respondent state, let the matter be listed on 18/7/2023 at 2 p.m. In the meanwhile, the respondent state shall file an affidavit clearly stating that out of the declared 10 vacancies which are advertised, how many persons have joined and presently how many vacancies are available against the post of junior clerk against the 10 posts. In this regard, we would like to clarify that the vacancy positions be stated as on 19/7/2012. It has been stated by the Law Council for the appellant that one of the selected candidates had resigned. It may be further pointed out that as against the 10 vacancies, 9 candidates were selected, and out of them 8 candidates joined, and as stated, 1 candidate had resigned. As a result, 7 candidates joined and occupied the post. The respondent states have clearly stated that whether the 2 candidates as mentioned above left the post permanently or not, whether have they kept any lien on the post, that apart, the revised merit list as has been prepared in terms of the order dated so-and-so, passed in writ appeal number so-and-so, shall be placed before the court under the seal cover. Now you also look to the affidavit filed by the state. They have also disclosed everything. internal page 3 of their affidavit. The affidavit has been served on me on on 17/7/2023 yesterday.
Okay.
Let's say come to paragraph 5. It is humbly submitted that, let's get it. Mate order nahi, more to copy diya tha. More to copy out.
State is not giving any copy to us. The difficulty are facing, they is not given copy to us.
Yes.
I'm giving my copy.
They're not giving copy.
Well, I have made a
And
Xerox
even
copy. I have made a Xerox copy and a copy
was
extra.
directed to you, sir, because I am appearing in 2-3 cases for this Vijay Kumar period. No copy has been served, except 1255, no other copy. And now counter they have filed, they're
No,
not.
not the counter, it is a only affidavit.
But my lord, the issue is, my lord, the order of the
Oh,
with
ठीक है,
permission
let-
of my
let it
senior.
pass.
We are going away from the issue
ठीक है,
involved in
just
this
go
writ
ahead.
appeal on the orders passed in the writ appellate court.
You'll also
Looking at the
kindly
first
look.
case. That
You'll
is the
also hard this
difficulty
matter
we are
at length.
No,
That it is
never
hum-
been hard. Only
Just-
on their adjustment, they are arguing.
Para
That's
5.
all right.
Para 5. It is humbly submitted that the 10 numbers of vacant post of junior clerk of registration office of the Jagatsinghpur district was advertised by advertisement number dated 19/7/2012. The details of the vacant post advertised are given below. 10, that means UR2 male, SCBC 2, schedule caste 1, schedule tribe 1. Total thus it come to 10. The written test for the above post was conducted on 5/1/2014.
You are reading
And-
for which part?
Para 5 million of the additional the affidavit filed today. Affidavit on behalf of respondent
All right.
3 and 4.
Yes, yes.
They have must have filed it yesterday because they have served me a copy yesterday.
Yes.
Did you get it?
Okay.
Yes, I'm reading again. It is humbly submitted that 10 numbers of vacant post of junior clerk of registration officers of Jagatsinghpur district was advertised by advertisement number dated 19/7/2012. The detail of the vacant post advertised are given below. 10. You also see UR3, SCBC 3, SC2, and ST2, thus total 10. The written test for the above post was conducted on 5/1/2014 and total 485 number of candidates attended the said written test. It is submitted that, para 6, submitted that as per the proceeding of the selection committee meeting held on 25/6/2014, out of 485 number of candidates attended, 26 number of candidates, that is 1 is equal to 3 ratio of the vacancy advertised, were allowed to appear the computer practical test for 15 marks and qualifying in nature, which was held on 30/6/2014. The selection committee also decided to fix 10 marks out of total 50 marks for scheduled caste, scheduled tribe candidate, and 15 marks out of 50 marks for other candidate to qualify in the said practical test. The category-wise detailed 26 candidates, also skip over. Next page. Total number of 26 candidates were called for to appear the computer practical test. Then para 7, it is humbly submitted that on the basis of the result of the computer practical skill test, the selection committee recommended 9 numbers of candidates out of 10 number of vacancies advertised for appointment. List of 9 candidates whose names were recommended by the selection committee is filed herewith as annexure once. That it is humbly submitted that out of 9 number of candidates recommended, 8 number of candidates joined, and 1 candidate who belonged to scheduled tribe category, namely Deepak Kumar Pradhan, did not join. Further, out of 8 number of candidates joined, 1 candidate who belonged to UR male category, namely Jagannath Patra, placed her serial number 2 of the appointment order dated 1/7/2014, resigned from the post public service with effect from 16/3/2015 by letter number so-and-so of the district sub-register Jagatsinghpur. Balance, even 7 number of candidates are now continuing. Let's mark it. Then next page, para 9. That it is submitted that out of the declared 10 number of vacancies, 9 persons were issued the appointment order. Out of them, 8 number of candidates have joined and 1 candidate, namely Deepak Kumar Pradhan, did not join. Further, out of 8 number of candidates joined, 1 candidate, namely Sri Jagannath Patra, resigned from his post public service with effect from 16/3/2015. At present, there are 3 numbers of vacancies out of the 10 posts advertised. That it is submitted the vacancy position in the post of junior clerk as on 19/7/2012 was 10. Out of the said 10 vacancies, 9 candidates were issued with the appointment order, out of whom 1 of the selected candidate did not join. Again, out of 8 candidates joined, 1 candidate had resigned. At present, 7 candidates joined and occupied the post. It is submitted that out of 10 vacancies, 9 candidates were issued with the appointment order, out of whom 1 candidate, Deepak Kumar Pradhan, did not join. Thereafter, out of 8 candidates, 1 candidate, namely Jagannath Patra, resigned from the post permanently. So 2 posts, 1 did not join and 1 resigned, are vacant. So total number of 3 posts are now vacant. It is submitted that in compliance to order dated, they have filed this affidavit. Now, I have filed an additional affidavit. Give me, kindly look to that. Also, on the basis of that para 12, I kindly come to that affidavit. Don't like it. I have the hard copy I have given to LRC because yesterday they had given it.
You filed on?
Today I'm filing, not in the court itself.
Oh.
I'm giving the copy to my copy. This is based on the records. At the information, they are correct. The total out of that in 2012 advertisement, out of 10, 3 vacancies are available. But still, I have also said like this. Para 2. That the aforesaid writ application was listed before this Honorable Court on 10/7/2023, and on that date, the Honorable Court wanted to know about the vacancy position as to out of the declared 10 vacancies, how many persons have joined, and presently how many vacancies are available against the post of junior clerk against the said 10 posts. Pursuant to which the state government has filed an affidavit and have served a copy of the same upon the council for the appellant on 17/7. Whereupon at paragraph 9, they have clearly admitted there are 3 number of vacancies against the 10 posts as advertised. Para 3. In the meantime, the present appellant has come to know from the RTI application before the district sub-registrar Jagatsinghpur, seeking for the vacancy position of junior clerk in the district of Jagatsinghpur as on date, to which the district sub-registrar Jagatsinghpur supplied the vacancy position of junior clerk in the district of Jagatsinghpur as on 14/7/2023. And from a bare perusal of the information supplied, it is evident that as on 29 posts of junior clerk in the district of Jagatsinghpur are lying vacant. The copy of the information supplied by the district sub-registrar Jagatsinghpur is annexed as Annexure A/1. In para 4. In the meantime, during the pendency of the aforesaid writ appeal, the present appellant, because these out of these 7 persons, they are the appellant before lordships, those who are continuing from 2014. Now they have completed about 9 years of service. In the meantime, during the pendency of the aforesaid writ appeal, the present appellant has already been promoted to the post of head clerk by the office order number 240 dated 7/12/2022 and has been posted to the office of the same office SRO, Sub-Registrar Office Raghunathpur. The present appellant, after receiving such order of promotion, has already joined in his place of posting on 9/12/2022. Then para 5. It is also pertinent to mention here that one of the appellant in writ appeal number 1258 of 2022, namely Chittaranjan Sethi, by notification number 1, February 2023, selected and promoted to the Odisha Revenue Service Group B in level 1 of the pay matrix 2017 by way of promotion against the recruitment year 2021, and accordingly, as per the government notification, she Sethi joined on 10/2/2023 forenoon as assistant collector at the office of the collector of district magistrate Bhadrak. Then para 6. It is submitted that one person, namely Sarada Prasan Mahanti, who stood at position number 2 of the order number so-and-so dated 19/6/2017, selected as junior clerk and joined the job on 23/6/2017, and as such continuing as junior clerk since the date of his joining. That is copy of the order that is once. Those documents I have supplied. Also look to the first document is the information supplied by the district sub-registrar. The total number of 29 vacancies are available as on 14/7/2023. That is at page 5. And the next page, you'll also see that so far the present appellants, out of the present appellant, one of the appellant has got promotion also on 7/12/2022. That is, you also look to that. 2 Lakshmi Prasad Mahapatra promoted to the rank of head clerk, and 3 Chitaranjan Sethi, he is one of the appellant, posted in so and so, promoted to the rank of head clerk. Then the next is 14/2/2023. He has already joined and submitted joining report that has been accepted in the promotional post. Likewise, the district sub-registrar Jagatsinghpur also, so far on the recommendation of the staff selection commission, the other appellant has also been promoted and continuing as such. Now, my lord, the whole question for consideration, your lordship, why you lordship asked that question? Lordship, kindly look to my date chart, which I have already placed before lordship. No merit recording. Yes. The only thing from the date chart, your lordship can see in 2014, these are the admitted facts. Selection was made, interview was made, written test was made on the basis of the written test. So far, the present appellants are concerned for whom I am appearing, Mr. Pamira, Madam Pamira is appearing, all are qualified, and they are allowed to appear in the viable test, and they become successful, and the appointment letter was issued, and they joined. Subsequent to that, their joining, there are some query that there are some mistakes committed during the course of the evaluation of the written test examination by the Board of Secondary Education. So therefore, a letter was issued by the state government directing the collector to terminate the service. At that stage, they approached the audit tribunal, and the tribunal passed an interim order that now they are continuing. There is no, so far as their continuance is concerned, they are continuing by virtue of the interim order. 9 years, they have already continued, and they have got promotion, as I have shown to your lordship. Your lordship wanted to know that if there are 10 number of vacancies in that very advertisement.
All the applicants did not get promotion. Only, you have pointed out only 3 got the.
Yes, sir. Sure. So now your lordship wanted to know if out of 10 number of vacancies, 7 joined and 3 vacancies are still available. So now the question is, and that so far the other 20 vacancies, 22 vacancies are there. That is, as on today, there are 29 vacancies. That at least for the time being, also pause for a moment. But those are persons, there are 3 persons. One is the persons of Mr. Das client. He is Vijay Kumar Sahu, Vijay Kumar Parida. In fact, there is no dispute that he can, in the merit list, he is coming. There is no dispute over that. He can be accommodated also in the as against the vacancy of UR. Though he has, yes, he is SCBC candidate. SCBC, but as per your merit also, you can be selected also. Okay, all right. SCBC can. There is also a vacancy of SCBC. There is no dispute for that. So far as Mr. Lenka's client is concerned, he is another person who is also with your lordship. There is also a vacancy. So the only question is, because your lordship on that day I cited the judgment, your lordship look to the judgment 2 or 3 paragraphs. Why your lordship asked this question? Your lordship kindly look to that judgment I have given to your lordships. That is, first judgment is Gaurav Pradhan, that reported in 2018-11 SCC page 352.
Is it there? Is it not scanned? I find.
First judgment, sorry. First judgment is Vikas Pratap Singh. I think you also get it. Vikas Pratap Singh, you also see the first paragraph. But exactly the same question was raised. These batch of appeals are directed against the common judgment and order passed by the High Court of Chhattisgarh in writ petition number so and so, whereby and whereunder the High Court has dismissed the writ petition filed by the appellant herein and confirmed the revised merit list drawn after the selective reevaluation of the answer script of all the candidates who had appeared in the main examination for the post of Subedar platoon so and so 3. The appellant before us in SLP number so and so batch and 26 candidates agreed by the cancellation of the first merit list and withdrawal of the second revised merit list by Chhattisgarh Professional Examinations Board, whereby their appointment to the aforesaid post have been cancelled. Then the lordship kindly come to paragraph 18. It is brought to our notice. Let's get it. It is brought to our notice that in view of the interim orders passed by the one single judge, the appellants have now completed their training and have been in service for more than 3 years. Therefore, the only question which survives for our consideration and decision is whether, after having undergone training and assumed charge at their place of posting, the 26 applicants be ousted from service on the basis of cancellation of their appointment, qua the revised merit list. Then you also kindly turn to paragraph 20. Paragraph 20. The illustrates so and so the magic has never lost its temper over the centuries. Para 20. And this continues to dwell the spirit and body of the service law jurisprudence. It is settled law that no legal right in respect of appointment to a said post vests in a candidate who has obtained the employment by fraud, mischief, or misrepresentation or malafide. Then various judgments have been referred to. It is also settled law that person appointed erroneously on a post must not reap the benefits of wrongful appointment, jeopardizing the interests of the meritorious and worthy candidate. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of the appointees, and upon discovery of such error or irregularity, the appointee is terminated, this court has taken a sympathetic view in the light of the various factors, including the bona fide of the candidate in such appointment and length of service of the candidate after such appointment. Then the paragraph 26 and 27 at page 8. In our considered view, appellants have successfully undergone the training and efficiently serving the respondent state for more than 3 years, and undoubtedly their termination would not only impinge upon the economic security of the appellant and their dependent, but also adversely affect the, sorry.
Yes.
Yes, sir. In our paragraph 26, in our considered view, the appellant have successfully undergone the training and are efficiently serving the respondent state for more than 3 years, and undoubtedly their termination would not impinge upon the economic security of the appellants and their dependents, but also adversely affect their careers. This should be highly unjust and grossly unfair to the appellant, who are innocent appointees of an erroneous evaluation of answer script. However, their continuance in service should neither give any unfair advantage to the appellant nor cause undue prejudice to the candidate selected qua the revised merit list. Accordingly, we direct the respondent state to appoint the appellants in the revised merit list, placing them at the bottom of the said list. The candidate who have crossed the minimum statutory age of appointment shall be accommodated with suitable age relaxation. The next judgment is by page 9, one paragraph I will show you, paragraph 9. Paragraph 9. The very judgment which is cited, that was been referred to, that Vikas Pratap Singh's judgment, and paragraph 9 towards the bottom, in middle portion, a similar situation arose in Vikas Pratap Singh's case.
Amol Kumar Tiwari.
Yes, sir. Anmol Kumar Tiwari and others versus State of Jharkhand. I have page marked as page 9 of my bunch I have given to you.
You are reading in para 9.
By para 9.
Two issues is arise. This is
a similar situation arose in the middle portion of paragraph 9. A similar situation arose in Vikas Pratap Singh case. Does you get it?
Yes.
Where this court considered that the appellants therein were appointed due to an error committed by the respondent in the matter of valuation of the answer script. As there was no allegation of fraud or misrepresentations committed by the appellant therein, the termination of their service was set aside and it would adversely affect their careers. That the appellant therein had successfully undergone the training and were serving the state for more than 3 years was another reason that too by virtue of an interim order. was another reason that was given by the court for setting aside the order passed by the High Court. As the writ petition are similarly situated to the appellant in Vikas Pratap Singh's case, we are in agreement with the High Court that the writ petitioner are entitled to relief granted. Moreover, though on pain of the contempt, the writ petitioner have been reinstated and are working at present. The second issue, Lordship may not, then kindly come to the last judgment I am showing to Lordship. That is at page 14. Page 14, para 26 and 27. That is at page 24. Running page 24. Page 24. Para 26. This is reported in a batch of cases reported in 2018, volume 8 SCC, page 81. Para 26 and 27. Para 26. Does you get it?
Yes.
In the affidavit filed by the commission, it is mentioned that result has been revised of only 311 appellants who are before this court. We are of the view that key answer having been corrected, merit of all candidates except those who have been already selected needs to be redetermined. In our order dated 16/1/2018, it is mentioned that this exercise shall not affect those who have already been selected. We thus are of the view that the commission should revise the entire result of all the candidates except those who have been selected on the basis of the report of the expert committee and publish revised result of all the candidates. When the key answers are correct of the candidates who appeared in the examination, they are entitled for revision of the result. Since fault does not lie with the candidates, but lie with the examining body, it shall not be equitable to not extend the benefit to those candidates who have not come to the court being satisfied with the steps taken by the commission and its earlier expert committee, which was given the task of revising the key answer. Then the conclusion is paragraph 27. In view of the foregoing discussion, we dispose of the appeal with the following direction. First is Rajasthan Public Service Commission is directed to revise the result of all the candidates, including all the appellant, on the basis of the report of the expert committee constituted in pursuance of the order dated so and so, and publish the revised result. 2. While carrying the above exercise, the commission did not revise the result of all those candidates whose names were included in the select list earlier published. We having already pointed out that the appointments shall not be affected by this exercise. There is no necessity to revise their result. Thus, the exercise shall be undertaken, excluding all the candidates who are included in the select list. Commission shall publish the list. And another judgment I have not produced with your lordship. That is Gaurav Pradhan versus State of Rajasthan, reported in 2018-11 SCC, page 532. Para judgment behind para 48-49. There, that lordship have said, even if there is no vacancy, supernumerary post can be created to, because they have, that is what. So that judgment I'm giving to your lordship. So, sorry, not I'm giving an extra copy to the judgment. Para 48 and 39. There. So now you also kindly look to the judgment, impugned judgment.
Yes.
The Honorable Single Judge has noted this, but somehow, so far the principle decided by the Supreme Court, which has been referred to, let's look to the judgment. That is at paragraph.
Paragraph
You
14.
also kindly come to page 102. The judgment, internal page judgment 17. 101, page 101 of the brief. That is writ appeal number 1260 of 2022.
100 page.
You also look to the judgment, paragraph 12. I am reading only that portion where the Honorable Single Judge has noted this ground also. Right. Yes, page 12, right? Internal kete, page 16 was there. Page 16.
69.
Yes. Page 16 of the internal page of the judgment.
Okay.
101. Landing page 101.
That's all right. Page 16 or page 18? 101 is page 18. You're referring to
Oh,
which
sorry.
paragraph?
Because your lordship is holding another brief, I am referring to 1260. Yes, that one.
I'm only 126.
Yes, yes. Paragraph 12, your lordship come to
Yes.
subparagraph.
It is
On the
99.
other hand,
It is 99 in the paper book.
sorry, nice.
Okay.
Sir, I think there's some discrepancy. On the other hand, you also get it, Mr. Rautrai. That starts with paragraph 12, GR settled on counsel appearing for the petitioner.
And the next subparagraph.
On the subparagraph. On the other hand, Mr. Buddhadev Rautrai on counsel appearing for the private opposite partner of 5 and 6 has argued that the petitioner has no locus standi to challenge the process of selection since it's settled law that the candidate who has subjected himself to a particular selection process cannot question it later on. Let's just skip over. Mr. Rautrai further argued that the candidate who has selected and appointed cannot be blamed for the wrong committed by the Board of Secondary Education. Moreover, it is not a case where the petitioner are alleged to have practiced fraud or misrepresentation of fact to get appointment. Therefore, having been appointed bona fide and having served the government satisfactorily for more than 7 years, the petitioner cannot be thrown out of the employment at this belated stage. So this particular question, which I have cited also those judgments, have somehow not been considered by the Honorable Single Judge. If your lordship will look to paragraph 27, of course, the Honorable Single Judge referred to a judgment, but for different context, not to this. So for this, admittedly, my lord, on the basis of the merit list, original merit list, we have been selected, and on the basis of the interview, we have been appointment letter was issued, we got the appointment. And in the meantime, my lord, out of 7, 6 persons have already got promotion to the post of senior clerk, from junior clerk to senior clerk. And 1 person has already promoted to the post of head clerk. Now, therefore, your lordship wanted to know from the state that if how many vacancy of that advertisement is still there. They say that 3 vacancies are available, and further vacancy, 29 vacancies are, total number of 39 vacancies are continuing as on date. That is the latest information which has been supplied by the.
But how can you just seek your accommodation against the 29 vacancies?
That your lordship. That is your lordship can also direct them to create a supernumerary post in view of that judgment. But as your lordship rightly said, those are the vacancies that has to be advertised, and that is another part. And out of those 3 vacancies, and the persons, those who are 3 now claiming, that is for your lordship to consider that. And that is my entire substance, my argument. That is why your lordship are directed to the state to file the application.
Last occasion, my lord, directed to
I think Mr. Das will address now. Then you address it.
Last occasion, my lord, directed to produce the revised merit list in a seal cover.
That is there. Is there any drastic change in the merit list?
Yes. Yes.
No, I have not seen mine.
Yes.
All right, let us see.
They will not get mine.
The revised marks have been
No,
published.
you make your argument, we will see it.
We'll
How
go
it
to the
has
merit.
developed. No, keep it with the file.
Lord, I am in WPC. No, sorry, WA number 1255.
You are not in the present writ petition, that is 1260.
1260, I don't have the copy. 1255 of 22, I have a copy. So
all right, no
I can
problem.
submit on that. Because none of the other parties have given a copy. This copy I have prepared. 17. Well, before going into the interim, the impugn judgment of the Honorable Single Judge, the basic facts in 2 lines I am to submit. Why this dispute? There was an advertisement in Jagatsinghpur district for 10 vacancies for the post of junior clerk.
These are all known to us.
Yes,
which
but
already
that's the time
discussed. Yes.
come to a conclusion. 2 to 3 lines only, not more, I would say. The selection was directed to be conducted by the Board of Secondary Education Odisha, which is an autonomous body. Because at the relevant time, they could have sent it to staff selection or selection board, or they have entrusted it to the Board of Secondary Education Odisha. The Board of Secondary Education Odisha called an written test comprising of 4 set of questions
A, B, set A, set B, set C, set D. 4 set of questions to different candidates they have given. So all the candidates, they have appeared for these 4 sets with these 4 set of questions. But surprise, because that is a short question type and they have given a computerized format to give answer. They have supplied a key answers to the public domain only in respect of group A to all the examiners. The computer has been fed with the answer of group A, set A questions, so that we the candidates, those who have appeared through B, C, D sets, there was a discrepancy in marks because only A set question paper that was valued, other questions that was not properly valued. So that is
the key answers key was not published.
no,
also.
only one set of answers key for 4 set of questions. One set
That
of
is only for
answers.
the set A question papers.
Yes. That is why the dispute came, madam. And basing on that, because at the relevant time we are not known what is the fact. After that result was published, we apply under RTI Act and all this came to the light of this. So at that juncture, I have applied, my client Vijay Kumar Parida has applied for SCBC category.
There
and
was
the revised list is that
there was a reservation also for SCBC candidates.
yes.
How many
There
posts?
are two posts for SCBC.
2 posts. Okay. Please proceed.
My lord. And on the basis that today's affidavit of the state, they have given the list annexure B/3. I have seen just now. There, my lord, they have stated that old list, basing on that only one set of questions, key answer. They have published the result where my client has secured only 206 mark. And the opposite party is in that case, that Purnachandra, in this case, that Purnachandra Naik and another, my lord, just. And Priyavrata Rai, those two are the SCBC. They are shown to have secured more mark than me and selected and appointed.
Okay.
So at that juncture, I came to the tribunal way back in 2014. I am the first candidate who approached the tribunal.
Yes.
The matter proceeded with. And the tribunal, in the tribunal also, the board has published, when the matter was in the court, the government has also, after getting all these informations, the government has also proceeded. Collector directed the Board of Secondary Education Odisha, you please give the revised marks because this is not the correct marks. So they have published a revised mark, which was on the public domain. And from that, I filed it with my rejoinder there, wherein, my lord, so far SCBC is concerned, I have secured 256 mark, whereas this Purnachandra Naik has secured 222 mark, and see Priyavrata Rai secured only 214 marks. I am the person has secured highest mark as per the revised list published by the Board of Secondary, revised marks published by the Board of Secondary Education Odisha after correction.
This position is admitted by the parties.
Pardon, my lord?
That you secured the highest mark.
They have published it. They have given it in the court that was published. So, my lord, in the meantime, the matter we have gone there in the tribunal, matter went to this honorable court, and honorable court has passed this order. Now, kindly see what is the judgment. The honorable single judge.
Yes. That's all I think. Is it
Yes.
claiming on the basis of the position?
Pardon me?
Claiming on the basis of the merit position.
Yes. My lord, these persons, what happened? Actually, when they have corrected the marks, they have terminated all these 7 persons. Those who are in service. They filed independent original application in the tribunal and obtained a stay order. By virtue of a stay order, they continue. Not that they are continuing on their own. The wrong committed by the state has been rectified and they have been terminated, and the termination they have challenged and they continued. So by virtue of this stay order, though they are continuing, the government is so benevolent and now they give them promotion, 2 promotion. 1 person has got up to head clerk. I am fighting out my litigation, and this is my position in the merit list. And the honorable single judge kindly see, has formulated the points at para 17.
Para 13,
13, huh?
Yes.
internal page 17. Internal page 17.
Page 98 of the judgment, internal page 17. Has and the issue. That will be, if my lord is holding this 125522, then the running page will be 98.
You just refer to the judgment because I
Yes, madam,
opened the
yes.
judgment.
That judgment,
Yes.
internal page 17, para 13.
Yes.
Towards bottom, my lord. Point of consideration, point for consideration. Shall I read that?
Read.
Might. Points for consideration. From the rival contention noted above, it is evident that the following points arises for consideration in this batch of writ petition. Whether 7 selected appointed candidates have made out any case for interference with the impugn order dated 26/15 of the government in revenue and disaster management and notice dated 29/6/15 issued by the collector Jagatsinghpur. If so, to what relief they are entitled to? Then whether the 3 non-selected candidates are entitled to the relief claimed by them, if so, what extent? And thereafter analysis of finding. Since the facts have been narrated in extenso herein above, yes, sir, herein before, the same are not referred to again. It would suffice to only note that the evaluation of the answers by the Board of Secondary Education was seriously flawed to the effect that the question said being identical, the answer key also should have been identical for all the 4 set of questions. On a complaint being submitted by some candidates before the collector Jagatsinghpur and the BSc, the collector, as per the letter dated 17/9/14 and 26/9/14, requested the BSc to verify and re-examine the evaluation papers and to furnish necessary clarification. As per the counter affidavit filed by the BSc in WPC OSC number 3375/15, the result was revised and handed over to the authorized officer, and the result was also preserved basing on this scoring key prepared in respect of the question set in district number 1. By letter dated 4/5/15, the BSc informed the ADM Jagatsinghpur that the result of the district number 4 Jagatsinghpur was revised and sent for examination and necessary action. In the meantime, however, the selection committee met under the chairmanship of the collector to examine the veracity of the complaints lodged by different candidates, and it was found that the evaluation of the answer key had not been correctly made and illegality was committed at the level of the BSc. Therefore, by letter dated 6/5/15, the collector wrote to the government in Revenue and Disaster Department seeking instruction in the matter. Be it noted here that in the meantime, the appointment orders were issued to the selected candidates on 1/7/2014. The above facts imply that the original select list prepared by the BSc, which was based on wrong answer key, had been duly acted upon by the concerned authorities. But the revised select list, which was also communicated by the BSc to the collector by letter dated 4/5/15, was not acted upon. The collector sought instruction from the government 2 days later, that is on 6/5/15. Though the mistake was pointed out by the collector and the BSc was blamed for the glaring mistake in evaluation of the answers, no mention was made of the fact that the BSc had subsequently revised the select list by utilizing the correct answer key. Be that as it may, the government and Revenue and Disaster Management Department sought for opinion from the Law Department, and basing on the opinion tendered by the said department, the government decided as follows. I am directed to invite a reference to your letter number so-and-so dated 6/5/15 on the above noted subject, and to say that views of the Law Department was sought for in the matter and their views reproduced as follows. The selection process is completely illegal and the list of successful candidates prepared by the Board of Secondary Education Odisha should not be given effect to. 2. The candidates who have already joined in the post of junior clerk are to be terminated as the basis of their appointment is completely wrong. The recruitment process is to be cancelled and the fresh recruitment may be conducted. The damage claimed by any candidates should be realized from the Board of Secondary Education Odisha, as the process of recruitment has been dealt in a most irrational manner. However, the above narrated views are subject to outcome of the order of the Honorable OAT in way number 2373C of 2014. That was filed by me. You are therefore requested to take further necessary action on the matter immediately as advised above. Basing on such instruction, The collector requested the district registrar Jagatsinghpur to terminate the junior class already appointed and also issued to the impugn notice dated 29/6/15 in cancelling the entire recruitment process. In course of argument, Mr. N.K. Praharaj, government advocate appearing for the state, has pointed out that decision was taken by the government entirely on the basis of the opinion tendered by the law department. This court of after perusing the concerned file of the Revenue and Disaster Management Department produced by the land government advocate, observed that the fact that the select list had been revised by the board and duly communicated to the collector had not been intimated to the law department. Even otherwise, after such decision, the file were referred to the law department on as much as 4 occasions, raising different queries. Significantly, in its opinion tendered on 23/2/21, the law department stated that after calculation of marks in the answer sheet, if there is any error, a fresh merit list may be prepared. If the petitioner Vijay Kumar Parida is in the revised merit list, then he may be given appointment and the representation of the petitioner may be disposed of accordingly. Again, on reference being made to the administrative department on the following queries, it is not made clear that whether the 7 junior clerks who are continuing at present as senior clerk by virtue of tribunal order will be allowed to continue after recasting the merit list irrespective of their position in the revised merit list, or it will be decided as per the revised merit list. Whether rejection of their case will not amount to contempt of court. Whether after revision of the list, another case will be filed in the Honorable Court against the order of the Honorable Tribunal. Whether it will be pertinent, entertained at this belated stage. Law department opinion was as under. The revision of the merit list will depend on the final order of this way by the Honorable High Court. The administrative department is also required to file an application for revision of the order of the Honorable High Court dated 18/12/2020 in WPC 35311 of 2020 with a prayer for hearing of the revision petition as well as the above way analogously to avoid any conflict of orders. After final disposal of these ways, revision of the merit list may be taken up as per the order of the Honorable High Court, and there would be no apprehension of contempt of court. If the administrative department proposes to take action as per the above views of this department, they may resubmit the file for order of the government. Thus, it is seen that law department has not given a clear opinion to set the matter at rest finally. Nevertheless, in view of the subsequent opinion tendered by the law department, the impugn order dated 29/6/15, which was based on the earlier opinion of the law department, obviously cannot be treated as final. What has happened in this process is no further decision has been taken by the government in this regard on the rush of the pendency of the writ petitions and ways. Having referred to the factual aspect of the list, it would now be proper to deal with the technical ground raised by the parties. It has been thus argued that the writ petition filed by the 3 non-selected candidates is barred by limitation and paid for non-implementation of the necessary parties. As already has been stated that non-selected candidate except Vijay Kumar Parida have approached this tribunal with a prayer inter alia to quash the written test result and final selection.
Mr. Das, just 1 minute, whether there is any rule in the High Court of Orissa regarding the limitation regarding filing of the writ petition?
I can't follow. Sorry.
Whether there is any rule which prescribe the limitation for filing of the writ petition?
No.
So this observation, how do you just defend this observation?
This observation of the Honorable Court has also answered it. But so far my client is concerned, Vijay Parida is concerned, he has come to the tribunal right in time. At the time, tribunal was there. I came. 2014 was
I think
the
this
result.
is only limited to this state administrative tribunal where that after the rejection or the filing of the representation within 6 months.
Like 1 year, but if file a representation, then 6 months will more, but 1 year is the
total
limitation.
1 year time.
So I came in within 1 year. 2014 was the result. I came in 2000. My case number 2373 of 2014. I came in time. Vijay Parida came in time to the tribunal.
So in your case, there is not that issue is very relevant.
Yes, but because there are many cases, my lord, so that is why the court has taken all the ways together and the common order was passed.
All right.
Now, my lord, so therefore, if you skip over this part, my lord, kindly come to 21, para 21. This is the first issue. 21. Around page 28.
Yes.
Coming to the main ground of challenge to the impugned order, there can be hardly any doubt that the BSc is primarily responsible for fiasco. However, it is borne out from the record that on complaint being lodged by some unselected candidates, BSc rectified its mistake by revising the result, but by such time the original select list had been acted upon. What has happened in the process is some eligible candidates have been left out, while others who are said to be ineligible were given appointment. It has been argued that the revision list cannot be taken into consideration because it would amount to re-evaluation of the answer script, which is also not permissible in law. It would be relevant to note here that the discrepancy as arising in the present case was also detected in the respect of Ganjam and Kandhamal districts. In the said district, the revised select list was published and appointment was given for such district, which was challenged before the Odisha Administrative Tribunal in way number 3462C of 2014, and based on the ground that after completion of the selection process, the selection committee had become a functus officio, and there is no provision under the statute for re-evaluation of the answer script. The tribunal in its order dated 20th July 2017 held that no re-evaluation had been done, but only because the error due to result processing system, the preparation of the merit list had been affected. Accordingly to the tribunal, correction of the error resulting publication of the revised list does not amount to re-evaluation of the answer script. This court is in agreement with the reasoning adopted by the tribunal, as the same situation has been arising in the present case. After coming to the know of the error in the answer script, the BSc corrected those same and prepared a revised list which was forwarded to the authorities. Therefore, the contention that the revised list cannot be acted upon is not acceptable. It has also been argued that 7 petitioners were appointed bona fide without any fault and their own, and there is no allegation of any fraud or misrepresentation of fact committed by them. Therefore, they have acquired a right to continue in their post. This court does not agree with such contention of reason that law requires that a candidate can be appointed only if he is found to be eligible in the recruitment process. In the instant case, the eligibility of candidate is to be decided on the basis of marks secured by him in the written test and vivacious test. If the revised list is taken into account, it would be evident that candidates securing less marks have been appointed, leaving out candidates with more marks. This casts fundamental question as regards the correctness of the appointment. It is settled law that if the very basis of the appointment is bad, any further action taken validates the same. The same case is stated in State of Orissa, Mamata Mahanti reported in so-and-so, so-and-so, so-and-so. Thus, in that Mamata Mahanti, my lord have quoted also, it is a settled law, settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action development cannot validate an action which was not lawful at the inception, for the reason that illegality strikes at the root of the order. It would be beyond the competency of any authorities to validate such an order. It would be ironic to permit a person to rely upon a law in violation of which it has obtained the benefits. If an order at the initial stage is bad in law, then all further proceeding consequent thereof will nonest and have to be necessarily set aside. A right in law exists only and only when it has a lawful origin. Thus, if a candidate not securing the required marks has been appointed, leaving out eligible candidate, the very appointment is to be treated as a nullity. Such was taken by the apex court in the case of State of Odisha versus the State of Bihar and others versus Devendra Sharma, reported to so-and-so. It has been strenuous.
This part you can skip.
Yes,
Citations, because these are the
yes, these are the no, because why I have read out this part, because my learned senior has stated, because this we have shown two judgments of the Honorable Court, the Honorable Single Judge had not taken note of that. But this is the right answer of the Honorable Court.
It's all right that you've taken. He has stated his two judgments, his referred was not taken care of.
Yes, that is why
whether that will change the this reasoning, we will examine that part.
Yes, that is my lord is there to examine. Yes. So in essence, my lord, my response submission is, because I think my lord have read out the judgment, I need not to repeat it. So only thing my response submission, kindly here the situation is, there was an examination, the examining body has committed the mistake. It is, I am not saying it is their fault or my fault, but fault is their fault. And a mistake has to be corrected. It is not such a mistake which cannot be corrected. And since it is a curable mistake and the mistake has been cured by publishing a revised list, all the appointments should be made as per the revised list. This is my submission, my lord.
Yes.
And that the Honorable Court has held it. And now revised merit list is before my lord. My lord you can open that list and see what is my position. Because I am standing here and a person, my lord, fighting
So
out
according
litigation.
to you, this persons doesn't figure in the reverse list.
Correct, my
There
lord.
should
My-
be
what
given
the
a
place. And
go
they
by
cannot also be. I am,
simultaneously after all these.
though I am
years.
not appearing for them, I can only say, my lord, as an advocate here. It is not their fault. They cannot be treated here as a fence sitter also.
That is what, that is what
That I am
Mr.
my submission.
Rautre has argued in a
That they
very
cannot.
sublime
My
manner.
response submission would be, in this particular situation, every case is to be decided on its own merit. And the fact involved in this case, those petty person, they don't know all this complicacy. Now their name come in the figure, in the final list. So if this list is to be complied, then those persons need to be recalled. Somebody may forego his appointment and they will get an appointment as per their position in the merit list. But not in this way, because they have been appointed someday and they are continuing by virtue of an interim order. So that also
That
didn't
you
give
have
them any rights. So this is all about my submission. When my poor client is fighting out litigation from 2014, he is an unemployed till date. But he is the number one in the SCBC category. And that paragraph 28, finally, my lord.
I think you have argued all your.
My lord,
points.
my lord, get me
Lordship,
correct.
little factual correction. One little factual correction based on law. Which this matter started in the tribunal. And tribunal specifically, your lordships, there is that it has to be confined to the applicant. It really cannot go beyond that. Mr. Das has been saying that he's holding the brief only for one candidate who has stood first in the exam. We don't dispute that. By virtue of the R.K. Sarwal case also, if he has stood first, he takes it as an unreserved category candidate. So there's no question over here him being the first in SCBC is first. So therefore he is in the in the unreserved category, which is open to everybody.
No, I am first in
So,
SCBC. You stand corrected.
Your lordships, he's first in the written exam.
SCBC, yes.
Only he's first only in his category.
Yes.
No, your lordships, that's the thing. He's not first in his category.
No.
That is the other day he just told us that he's first in his category only.
Yes. The revised list is with me, my lord. I have filed it to my rejoinder. I am first in my category. I have secured 256. Other two persons, those who have been appointed, Purnachandra has secured 222 and other person 214. Deobrata Rai.
First, the one who's in.
So I have not applied for you. I am a SCBC. I have to get an appointment of SCBC.
That's the point. That's the point. So therefore, anyways, and there is a UR post which is vacant, never occupied. So he gets taken care. As far as Mr. Sethi's client is concerned, he was an intervener. Even let's consider his case, but he is in job in the same department. Probably he's only claiming is a seniority from that date. So he is with the post, can be taken care. As far as Mr. Linka's client is concerned, that's a very interesting position. Mr. Linka's client approached the tribunal. She had a name in the list. She cleared the written exam. She failed in the skill test. She only got 2.5. So, and that there's a finding against her in the judgment itself, which is para 20. In my brief, it will be 107. Para 20 of the judgment, if your lordship will.
Yes. Anita Mahapatra.
This leaves the court with 20. Para 20 of the judgment.
Yes.
So that my brief is WA number 1255.
You just refer from the judgment.
20. May I place 20?
I
Para
have
20.
got it. Page
Look.
para 20.
So
yes.
therefore, she lost the battle precisely on that reason. Strangely, when this order was passed that you call the people again for a skill test, she was also called, but she could not have been called for simple reason that you did not clear then. You had cleared your returns. So you were not a victim of this wrong question mark. Your candidature was hit because you didn't qualify. So therefore, your lordships, this very list today which has been prepared by recalling people to attend the skill test is faulty on this ground. So Miss Anita neither gets it here, neither gets it there. So
And that has been done by virtue of order of this court.
I know, but they did it wrongly. Their implementation was wrong. That's the problem here. So therefore, the list which is there before your lordships, whether it is correctly done or not, is again under suspicion. That's one thing. So when Miss Anita is out here and this way, and Mr. Sethi anyways has a post only back, seniority is to be given, this leaves us only with one person in the UR post to be absorbed. And that UR post is available. So I think we all can be restored back, accommodated. That's all, you know.
My lord, may kindly see paragraph.
Yes. Ajay, just the petitioners and the intervener here, then you give a common reply.
Just to add to what Senior Mr. Rautra and Ms. Rath had said, I'll just add one more thing. Out of these 6 selected persons who were there, now the top 2 who were there, one of them has become the additional collector by virtue of appearing in the departmental test. So they have crossed the position. I understand what the legal issues stand.
There is a legal issue because the root appointment is jeopardized.
Yes.
That will have the impact on the subsequent.
No, I'm not saying the right so far as I'm just saying the factual position, what is there. Now, subsequently, my lord, it is more of a case like as Mr. Das was pointing out, the way he was pointing out, rather than like him getting there to oust the others who have been there already. So that is not the purpose of the writ appeal, nor for the purpose why the challenge has been made, as my senior Mr. Rautra pointed out from the judgments, that what has been done, if they can be accommodated parallelly without affecting, they can always come back in the seniority list as per the position they hold so far as the revised list is concerned. But those who have not approached the court, now because once the list is opened, then again it will be open the Pandora's box, because others will again come up and say that yes, we have a right. So for that purpose, it is more of a issue of equity rather than purely question of law that has to be, your lordships have to consider.
The problem with the equity is that it is a very healthy words in the legal parlance, but problem when it comes in contrast with the legal position,
I understand.
It becomes a very perilous one to adopt such kind of an approach. So that we have to also examine that aspect of the matter.
No, your lordships have to balance out either way, like purely whether on the question of law or whether the issues which have been dealt with by my senior Mr. Rautra, that has also to be taken into account. So on that basis, because those people have already, because now they are out of the zone of consideration again for any other test, because they have worked for so much of time, they are now.
There is another problem, Mr. Nanda,
because they did not have
also
any...
At present, for purpose of the adjustment, only 3 posters available in the court.
Yes, and the petitioners who are before your lordships, or the intervener, or my learned friend Mr. Lenka's client also, I don't say he should not also get. Everybody can be accommodated. But as Mr. Das points out that the others who have been there, they should be called for and these people to be taken out. To that extent, I was just addressing your lordship.
No, he has taken a legal approach. He says, why not? Why not?
Oblige.
My lord, can see paragraph 28 of the judgment.
Yes.
My lord, your lordship, kindly see. My lord, in the revised list.
No, you are appearing in which matter?
In the first case, Anita Mahapatra,
Appeal in WA number 1437 of 22, my lord.
Onita Mahapatra has a problem.
My lord, in the revised list.
First screening, she was not found eligible because.
My lord, in the written test, I have qualified, my lord. And the skill test is qualifying in nature. And pursuant to the division bench interim direction, I appeared in the test again, my lord. I qualified and I hope in the revised list, my name is there. I am the.
Ms. Roth has challenged that part of the judgment.
My lord, I am also challenging that part of their appointment treated as illegal. Their government affidavit at phase 12, my lord. I'll point out, my lord.
All right. Thank you, Mr. Lang. Anything more to add?
I am a woman, you are. One post is vacant, that is held by my lord. The post is resigned, that is your post. Government of Jagannath Patra belongs to your. He tender his resignation at page 17, my lord. Of their affidavit. And page 12, your lordship kindly see their affidavit, government affidavit, page 12. My name in the merit list. So far, your woman is concerned. My name finds place at serial number 503, that is Anita Mahapatra. And the name of Suchismita Mahapatra, my opponent, my lord, respondent. His name finds place so far you are in the 5th line of the top, my lord. My name is, it is old list. This is old list, my lord.
All right.
And pursuant to division bench order of this honorable court, my lord.
No, that is
I have appeared
position.
And I hope I qualified in the
chance you have cleared it.
Your lordship kindly see the skill test in the advertisement, it has been mentioned. Skill test is qualifying in nature. That marks should not be counted. Well, lordship kindly see page 28, my lord, of the advertisement to my writ appeal 1437 of 2022, my lord.
Yes.
Practical skill test shall be qualifying nature. And pursuant division bench of the order of this honorable court, my lord, I have appeared and your lordship will see the results.
What does mean by the qualifying nature?
My lord.
Suppose you cannot succeed in the skills test. Is there any chance for your appointment?
My lord, I'm not able to.
No, I think that does it mean by the qualifying test? Suppose you cannot cross the skill test.
My lord.
Can you be appointed?
I have qualified in the. I hope I have qualified in the revised test. My list.
It's an absurd proposition.
In the revised list, pursuant to direction of the division.
No, then you qualify.
My lord, I have qualified.
Okay. Do you consider this is a very fair procedure? Someone could not qualify in the first.
My lord, that it is my alternative argument. But my first argument is your lordship publish the revised list according to revised list merit list. Thereafter, my lord, they have illegally appointed. By continuance of interim order, they have no right, my lord.
Yes.
As per Mamata Mahathi case, my lord.
Yes, yes. All right. We have taken note of the Mamata Mahathi's case. And based on the judgment, only the learned single judge has passed the order.
My lord.
So there is no problem in that.
I have intervened, my lord, in WA
You are also intervener.
Intervener. In the revised select list, my name finds place in serial number 3 as your candidate. Below the candidates, number of candidates have got appointment. If the revised merit list will be published, then I will get appointment above them. My position finds place in serial number 3, my lord.
You are appearing in which writ
in WA number 1257 of 2022. I have filed an intervention petition. I have also intervened in the writ petition, man. My name finds my soul.
Why do you intervene? Let us understand that. You do not have any right. Protect it.
But
what you coming? That is a substantive right.
I am bringing to your lordship that the illegally.
No, I am just trying to understand the position of law from you. Intervener may come to protect their existing or the vested right? What is your right? It has not been declared by any authority as of now.
I am only some facts bringing your
You can only
lordship's
make
knowledge.
submissions that this list should be followed for fairness of the recruitment.
I want to, this list should be followed.
Which list?
The revised list which has the status
Given
given.
here,
Yes.
this one.
Yes.
How do you know that what is there in this list?
The revised list is with me, my lord. In the revised list, my name finds place at a serial
Revised
number
list
3.
means this one.
Yes, ma'am.
How do you get this copy, Mr. Muduli?
I have not seen.
But
how he is getting a copy?
No,
I have
that is a
taken
different one. That is a different.
That is
Board-
board revised list.
Board revised list. I have-
Board
I have
revised list.
obtained
That
through
is, my
RTI
name
Act.
is also there.
That is after, that is.
Board has published the revised list.
Okay,
Board has
okay. That is
issued
the
in marks, revised marks,
revised
after
marks.
correction.
After
That
correction.
was
This is
filed.
a corrected list actually.
Corrected list is.
And it has been obtained through RTI Act.
I have
Okay.
filed it.
No, you are showing this yellow envelope. That is why I'm a little
No,
bit taken away.
That's my.
In the board list, all three names find press one.
All right.
My lord, can you see paragraph 28 of the judgment?
Huh.
That is internal page 36 of the judgment. Page number finds place at the bottom of the page. May I place my?
Yes.
In the ultimate analysis, this court is of the view that the government committed an error in not acting upon the revised select list forwarded by the BSc. This court is also of the view that the defect having been rectified, the entire selection process need not be cancelled. However, for the ends of justice, the revised select list should be acted upon. Any candidate possessing the requisite eligibility with respect to the different categories and post advertised has to be offered appointment. Consequently, if any of the 7 appointees is found to be without the requisite eligibility, he has to make way for the eligible candidate without claiming any equity. Now, in the next paragraph 29, all the directions have been issued. And this part of paragraph 29, it has been complied with and the result is in seal cover. Now, I'm placing a short date chart.
That is whatever action in under the seal cover is that based on the reverse list published by the board. Is it so?
I could not hear me.
Just the nature, the selection committee headed by the collector Jagat Singhpur
Yes.
shall convene a meeting of the committee within 2 months to consider the revised list submitted by the board.
Yes.
So whatever has been done in this list according to this direction.
According to this direction.
So there is no question of this reorganizing the merit list also because they are follow the merit list are published by the board
Yes.
after due revision.
Yes.
Okay.
Now, well, I will not place all those dates. My lord, can you serial 5. 1/7/2014. Appointment orders were issued to 9 candidates, out of which only 8 candidates joined. Subsequently, out of the 8 candidates, 1 candidate resigned from the service. Now, next relevant date is 6/5/11. Serial 7, 24/3/2015. On the basis of RTI Act information, written complaints were submitted by several unsuccessful candidates before the collector Jagat Singhpur alleging that the OMR valuation and result sheets of the candidates had not been properly evaluated as the answer keys provided by the BSc Odisha. The next is 4/5/2015. Secretary BSc Odisha informed the ADM Jagat Singhpur that with inadvertent mistake, 3 sets of question papers, set B, set C, and set D, were not jumbled in respect of paper 1, and accordingly the result was revised and handed over to the authorized officer. 6/5/2015, Collector Jagat Singhpur sought for necessary clarification from the Government in Revenue and Disaster Management Department. 26/2015, Government in Revenue and Disaster Management Department informed the views of the Law Department in the matter to the Collector Jagat Singhpur to cancel the recruitment process and to conduct fresh recruitment. 29/6/2015, Collector cancelled the recruitment process as well as the list of finally selected candidates and directed the district registrar Jagat Singhpur to terminate the services of the person who are continuing. My lord, your lordship, 2 relevant dates is 1/7/2014 was the date of appointment and the date of termination is 29/6/2015. So within 1 year, they have been removed from service. Now, whatever now they are claiming that they are continuing is all those are by virtue of interim order passed either by the Honorable Tribunal or by this Honorable Court. Now, 1/7/2015, there I have stated that regarding interim order passed by the Learned Tribunal. And all the facts have been placed by Learned Senior. I will place certain judgments.
Yes.
I've given the headings. Irregularities, if my lord permit, I can place those judgments. I've given the relevant paragraphs.
Okay.
A. Irregularities in the selection of candidates for appointment to the post of Sub-Inspector of Police, appointment set aside by the High Court that has also been confirmed by the Supreme Court. Appointment by mistake does not confer any legal right, appointment also set aside. C. Wrong appointment set aside after 17 years. Well, this is a short judgment. May I place, my lord, this judgment?
Ms. Patil judgment.
This 2010, serial C.
Ms. Patil, yes.
2010, volume 10, SEC, page 63. Well, that is flag C, my lord, we can see.
Yes.
This case sadly illustrates how interim orders passed by the court, coupled with judicial delays, ensure to the great advantage of the wrongdoer, and in the end make him bold in the false belief that with the passage of time, the equity was now firmly on his side. The appellant in this case was wrongly appointed to the post of reader in the Department of Kannada in Gulbarga University on the basis of the interim orders passed by the court, and evidently helped by the authorities concerned in the university. He has been able to hold on to the post now for over 17.5 years. Paragraph 3. In response to the notification, 11 applications were made for the post in question. Only 3 applicants were from Group B category and the rest were from different other categories. The appellant is from the general merit category. According to the appellant, the Board of Appointment did not find any of the Group B candidates eligible or suitable, and on the basis of the interview held on 5/6/1992, he was selected for appointment. His selection was approved by the syndicate on 1/2/1993, and a notification for his appointment was issued on 4/2/1993, in pursuance of which he joined the post. On 27/6/1993, respondent number 2 filed a writ petition WPC 22047 of 1993 in the Karnataka High Court, challenging the appellant's appointment on the ground that the post was reserved for Group B candidate. He also alleged that in a certain way, the appellant respondent number 2 in the writ petition was closely related to the head of the Kannada department of the university, and his appointment was the result of favoritism. Paragraph 6. A learned single judge of the High Court upheld the contention of the writ petitioner on both counts. He held that the selection and appointment of the appellant belonging to the general merit category to the post reserved for Group B category was illegal. The learned judge further held that the appellant respondent number 2 in the writ petition was closely related to the head of the department respondent number 3 in the writ petition, and therefore he ought not to have participated in the selection to the post of reader in Kannada. On behalf of the present appellant, it was also pleaded before the learned single judge that since he had been working for several years after his appointment to the post, he should not be disturbed. The learned judge did not accept the plea. He allowed the writ petition, and by the judgment and order dated 6/12/1999, set aside the selection and appointment of the appellant as reader in Kannada on the basis of the notification dated 30/3/1992. The learned single judge directed the university to fill up the post of reader in Kannada, calling for fresh applications and to complete the selection within 6 months from the date of the judgment. He, however, allowed the appellant to continue on the post till the selection process was completed. Then paragraph 10. By the time the appeal was heard by the division bench, 10 years had gone by and the appellant was continuing on the post. On that basis, it was strongly urged that it would be very unfair to him if he is forced to go back to the college from where he had resigned to join the post of reader in Gulbarga University. The division bench was, however, unmoved. It maintained the order passed by the learned single judge and directed the university to fill up the post of reader in Kannada pursuant to the notification dated 30/3/1992 giving opportunity to all the eligible candidates who have submitted their applications in response to the notification and complete the selection process within 3 months from the date of receipt of a copy of the order.
You come straight to the paragraph 17. That is where the law has been carved out.
Yes. We are unimpressed. Paragraph 17, we are unimpressed. In service law, there is no place for the concepts of adverse possession or holding over. Helped by some university authorities and the gracious circumstances of the interim orders passed by the court and the delay in final disposal of the matter, the appellant has been occupying the post for all these years that lawfully belong to someone else. The equitable considerations are thus actually against him rather than in his favor. So in this case, it is the finding of the court that these are irregular appointed. These 7 persons have been irregularly appointed. And that is why directions have been issued for recasting.
Are you supporting the learned single judge's judgment?
Yes, we are implementing.
Because you have cancelled the entire recruitment process.
Cancelled.
So there you are not standing by that decision now.
Now they are implementing this. Now they are implementing this.
That is what I'm asking you a straight question. That you are not supporting your own action now. You are giving into that. All right. That's all. I think that is the crux of your submission.
Yes. Then one paragraph
of
flag F, my lord, may kindly see. That is 2020, volume 20 SEC 209. And there, paragraph 80, my lord, may kindly see. Last but one page.
Paragraph 18.
80.
80.
That is page 250.
Yes.
We may also notice one more submission of the learned counsel for the appellant. The learned counsel for the appellant submits that in pursuance of selection dated 10/4/2010, the appellants were appointed and they have now continued for more than 9 years. And at this juncture, it is not equitable to throw them out from their post. In the present case, result of the selection dated 10/4/2010 was published on 11/4/2010 and the writ petitions were filed in May 2010 itself, and immediately selection was set aside by the single judge on 11/9/2012. The continuance of the appellants is only by way of interim order. This court has also passed an order on 29/11/2013 for maintaining status quo, which order has been continued till this date. When the continuance of a person on a post is by virtue of an interim order, the continuance is always subject to outcome of the litigation. The displacement of the appellants from their post is inevitable consequence of upholding the judgment of the High Court. The constitution of bench of this court in C. Channabosaya versus State of Mysore has made the following observations in para 9 in such a situation which is beneficial to record. It is very unfortunate that these persons should be uprooted after they had been appointed, but if equality and equal protection for the law have any meaning, and if our public institutions are to inspire that confidence which is expected of them, we would be failing in our duty if we did not, even at the cost of considerable inconvenience to government and the selected candidate, do the right thing. So accordingly, selections have been set aside. So in the instant case, within a period of 1 year, they have been their services have been terminated, and thereafter they are continuing by virtue of interim orders.
Okay, I think we just make it reserved. Just make a common order for all the writ appeals. Give the name of the counsel against the writ appeals. Hearing is complete. Judgment is reserved.
Single judge.
Before that you write, today the opposite parties The respondents number 2. In compliance of order dated 10/7/2023, has filed filed the affidavit. The said affidavit is taken on record. The respondents number 3 and 4 has also filed their affidavit in compliance of the order dated 10/7/2023 in the proceeding. So the same is taken on record. Stop. The respondent number is in WA number 1255 of 2022, 3 and 4. Huh? The respondent number 3 and 4 has also filed a similar affidavit in WO number 1256 of 2022, comma WO number 1257 of 2022, 1258 of 2022, 1259 of 2022, 1257 of 2022. We just filed the reference in WA number 1260 of 2022. So, one additional affidavit has been filed in WA number 1257 of 2022 by the appellant, placing some additional information as regards the vacancies. The said affidavit filed today in the proceeding is also taken on record. That apart, Mr. P.K. Madhuri, in terms of this course order, has filed the revised selection list prepared by the collector Jagat Singhpur in terms of the impugned order under the seal cover.
It was passed in writ appeal 1255.
No, this is a the order has been passed in the original writ petition. I mean, which has been now.
No, this seal cover, to produce the seal cover, that order was passed in 1255.
I understand. I said only this is the in terms of the passed in the year, that is also on asked to be filed in the seal cover.
Yes.
Order is passed in the land by the land civil judge. And so the appellant in WA number, for the appellant in WA number 1258. The date chart along with the notes of submission has been submitted and is placed in the record. The Mr. Muduri, an additional government advocate, has also filed the list of citation in WA number 1252 of 2022. This is also placed in the records, along with the seal cover is produced by him. That's then only you say, huh? Yes, the notes also clip it with it. Huh? On the next matter. Huh? Which matter? 456.
Item 56.
32, what is 32? Yes.
56.
In this item 56. In item 56, on last page, the lordship has directed me to take instruction. I have got that instruction, I have supplied. Your lordship said that in that instruction, lordship, see the second page. Second. However, considering the representation of the petitioners, which requires amendment of the file is under process, which may take some more time for disposal of the said matter. So some more time is required. My lordship can add.
How much time do you require?
2 months we have prayed. Your lordship may say that there.
We are fixing the matter on 28th of August.
Yes,
by the time take the government.
Yes, yes.
Let us see the what rules they frames. Mr. PK, Mr. Amma Kuntial, an additional government advocate, has placed before us the written instruction he has received from the Forest Environment and Climate Change Department on 13/7/2023. It appears that the government has taken some steps for amendment of the service rules. Stop. Mr. Kuntiya, the London Council has prayed for some more time so that the amendment of the rules can be finalized.
Well,
having taken note of that aspect of the matter, let the matter be listed on 28th of August 2023. We direct these opposite parties to complete the process of rulemaking and publication by the next date. Mr. Maulik, Land Council is appeared for the petitioner. The written instruction is received from Mr. Kuntial and additional government advocate is taken on record. Next.
Item 13.
Maybe.
Yes.
In this case, my lord, there is a delay, my lords. The file limitation petition, my lord.
Yes.
In fact, my lords, after 25 days, the writ appeal was filed, my lords. But certified copy was given thereafter, my lords. In Xerox copy, the writ appeal was filed.
Problem is the rule demands. It can be taken as a ground, as a sufficient cause that I had filed in the earliest opportunity, but I did not receive the certified copy. But the delay has to be there. So it has to be considered leniently, that much we can do it. Who is appearing for the state? Mr. Kunti, are you appearing in this matter, item 13?
13. That's limitation. Tell us,
183 is this delay. Because he could not file certified copy, but he filed the memo FAP. So we think it's in case we take a lenient view, whatever. Well, we condone the delay. It is item 13. You just check up IA number 4061 of 2023. IA. Oh, you just check up the number. Limitation application. 40. You have Mr. P. Deo.
My lord.
This IA 4061 of 2023. The last application number. Or Mr. P. Deo, learned counsel, appearing for the appellant applicant. There is an application under Section 5 of the Limitation Act for condoning the delay of 183 days in filing the intercourt appeal, challenging the order dated 23/9/2022, delivered in WPC number 20127 of 2022 by the learned single judge. Stop. According to the applicant, the said delay is wholly unintentional, inasmuch as the memorandum of appeal with a excerpt copy of the impugned order has been filed within time, as the certified copy could not be obtained. However, the certified copy has been filed, but on the date of filing certified copy, a delay of 183 days had taken place. Which one? Oh, so sorry, not within time. With a delay of 25 days, not within time, with a delay of 25 days. Stop. Mr. M.K. Kuntial and additional government advocate appearing for the opposite parties has submitted that, considering the peculiar circumstances of this court, the delay may be condoned. Stop. Accordingly, the delay stands condoned. The result of this application is allowed and disposed of. We'll take up the matter for admission some other day, not today. In view of the order, first no probably we'll list this matter on 31st of July. When? Give the date. 22nd August. 22nd August. Yes, call the next. Call 41 and 42 first.
41.
This matter, I think some other day. Give a date, closer date, partner matter. You're fixing on 16th August, but your these appeals are already. There are a lot of defects. You remove these defects.
Pardon, my lord. There is an interim order in both the cases, my lord.
Oh, that's all right. 41. Just defects you just see in the cost.
No, only prayer, my lord. The petitioner shall not be evicted without following the due process of law. That is my prayer.
It's all right. No, not in this. I'm talking about the defects you have not removed. In both the cases, same type of defects. In the appeal, there is a similar defects are there, both the appeals. You remove the defects, we are fixing the matter on 16th August. What is the matter again on 16th August 2023 for continuation of hearing is parted. It appears that the appellant has not removed the defects as identified the registry as yet. Within 3 days, you must remove the defect. Within 3 days, the defects shall be removed. Interim order is passed earlier, shall continue. Ms. D. Mahapatra, and counsel appears for the appellant. And Mr. D.K. Mahantil, and additional government advocate appears responded. All right.
42.
Same order in 42.
42 same, my lord.
Same, 41 and 40.
43.
43. It is also parted. Huh? It is not parted.
Court fee you have not paid, court fee. And one is a copy you have obviously given.
Already given.
53. 53 is a pattern.
53.
53 is a pattern. Yesterday, my appellant completed his
Yes,
Yesterday, the applicant has completed his argument.
yes.
If my lord permit, I can.
Where is the
Appellant is not here today.
53.
How will you know when the matter will be taken up?
It will take some time.
So.
I am for the respondent of 4, my lord.
No, it's
Yesterday,
all right.
applicant completed his argument.
Since the appellant is not there, we fix the matter some other day.
My lord, date may be fixed at 2 p.m. my lord. Any date next week
Okay, 17th August
at 2 p.m. my lord.
at 2 p.m. as part of for continuation of hearing. Huh?
Mr. Rath, you are appearing from whom?
Respondent of 4.
Just the none appears with the appellant of the matter is taken up. Mr. Kundia, you are for appearing for 1, 2, and 3?
Yes, ma'am. In that case, I am appearing state respondents. I am.
Exactly, those notings are there. Space. Notings are
In
there
that
on
case,
the-
I am appearing for
1, 2,
They
3.
have appeared, not necessary.
1, 2, 3. I appearing for 1, 2, 3.
My lord, 16th August, my lord. At 2 p.m.
2 p.m.
My lord.
17th August.
7th August at 2 p.m. my lord.
Mr. M.K. Kuntil, an additional government advocate, appears for the respondents number 1, 2, 3, and Mr. Rath. Council appears for the respondent number 4.
I have 35. I have a small prayer, my lord.
Just a moment. Yes.
Item 35. Matter was there yesterday, Mr. Mishra and me, we had requested it to be taken up today. Cannot be possible, my lord.
The problem is that
On Tuesday, can I pray for orders? Because I have filed an application for reconsideration of your lordship's earlier order. Can it be taken up for orders on Tuesday? I've also taken the consent of Mr. Mishra.
For order, just on the, you have filed the application?
Yes, my lord. There's an IA.
IA for recall of order?
Yes, yes, ma'am.
Which order was passed by us?
On the 3rd of March, your lordships had made an order for determining the right of way. So I have filed an application for recalling that order because there is no right of way on that part of the property. That's an independent land which belongs to the government and not the BDA.
No, just a minute. Let us see. Direction was on whom?
Direction was on the state government authorities as well as the BDA in collaboration with the municipality to determine whether there is a cause and inquiry and find out if there is a right of way abutting a 200 feet wide road.
Why recall of the order? If you're saying that no right of way is necessary, then why?
No, right of way can be given that way because right of way is on the eastern side, not on the northern side.
That you filed this application on 3rd of March?
No, 3rd of March was the order. I filed the application thereafter.
Okay.
I have 4827.
IA number 4827 of 23.
All right, matter will be taken up Tuesday.
On Tuesday. Obliged.
Lord, item 43, 44.
Yes.
Item 43 and
just wait. Yes.
On my prayer yesterday, your lordship, today it has been listed item 19. A small error in the village name that has to be changed. It should be Bodakul, but instead that it has been
item
written
number
as Balikuda. That is one thing. Item 19. And
just
the
wait, as we are taking this matter.
interim products.
Yes.
Let it come tomorrow. Madam.
No, today itself. What is the wrong in this order? Point out.
It should be Oracle. According to the petitioner, this change of location
Is
will
there-
cause serious disadvantage to the villagers of Balikuda. It should be Bodakul. Because
Bodakula.
we are representing the villagers of Bodakul. They are the RI building was
In the fifth line, it is written as Bodakula. Just read the order, Bodakula.
that is there. Last line that who will be in this disadvantaged position? That is our village, our villages. Bodakula.
Earlier it was Balikuda, now plan is Bodakula.
They are going to construct it at Balikuda. Balikuda people will not be affected. I will be affected.
What is the name of a village?
I am the villagers representing. I am the president is representing the villagers of Bodakula.
Bodakula, okay.
Whereas the RI office is going to be constructed at Balikuda.
Because he's the president of the village committee of Bodakula.
This last line.
Yes.
Just this in the order dated 6/7/2023.
And in my miscase,
Paragraph 3.
earlier miscase, no order having been passed, they are in war footing basis. I can enter.
That's already.
Today only for correction.
This is only you're taking.
No, I said tomorrow it will, because
No.
that day you also expressed that you should not do anything. They also said that yes, we are not going to construct. But taking advantage of this mistake, they have already put in their machineries.
This change of the location because there's this in para 3
That's line.
in the last line. After the words quote villages of unquote Balikuda has been wrongly typed. Instead of Balikuda, the name of the village will be Bodakula. So accordingly, in place of Balikuda in the last line of para 3, the word Bodakula be read and be substituted. Necessary correction be done in the order by the authority of this order. Stop. A copy of this order be supplied to the council for the parties forthwith.
Item
83.
Item 43 and 44. But I have challenged this honorable single judge order on the maintainability of the writ petition. Vehicles are deteriorating.
I am for the opposite party, my lord. Your lordship take up any date, your lordship.
The vehicles are, my lord,
I understand.
deteriorating in the rainy season, my lord. That can be the
Deteriorating. So they have not released deteriorating. I am for the petition.
Vehicle.
Your
only 43 or some other matter is there.
Such amount. Sir, no na the poisha ki gadi do na. Are kuch deteriorating. Now he is saying deteriorating. My lord,
on the date he filed the writ petition, the vehicle had already been sold.
No. How you?
An ex parte order was passed
Your
without even
lordship,
notice.
your lordship had this matter. Your lordship had.
Yes, lordship can have.
Had this matter. Your lordship date may be fixed.
You are referring 43.
43, 44. My lord, both
43,
there.
44, both these. There are 3 petitions.
My lord.
The honorable single judge has held that it is not maintainable in the impugned order itself. Still granted the final relief.
Final relief, my lord. Pay the amount, get the vehicle. What is the difficulty, my lord? I will pay the amount, my vehicle. Amount is this.
Why are you arguing?
No, my lord. Your lordship.
Let the matter be listed some other day. Just
Item 57. Your
just a minute. Propose a day.
My lord.
Your lordship.
27th is all right.
27th.
27th.
Item 27th July.
This matter on 27th.
Item 57.
Item
57.
43, 44.
43, 44.
In 43
I am
there are
suffering, my lord. I am
matters.
suffering, man.
All right, what is?
My lord, item 57, my lord.
Just a minute.
57, your lord.
Total 3. Total 3
57.
ଅଛି 43 ରେ ଦିଟା 44 ରେ ଗୋଟେ
27.
Yes,
What is
57.
your prayer?
Habeas corpus matter, my lord. The
Just a minute.
small child, my lord.
which item
57, my lord. 57.
You're 5-7.
Yes.
Ms. Patnaik
Yes, my lord.
is 57 recovered.
Last
Recovered.
Well, we have received instruction that they had gone out of the state twice to 2 different places.
Very good.
And the IAC has paid for 4 weeks' time in that. My lord, we are the next item. We have recovered one.
58.
58 going out of the state twice. and
57 is recovered. Which one recovered?
Paid for 4 weeks' time. They had gone outside. My lord, if you can reveal they have gone.
Mr. Mendes Land Council appearing for the petitioner has expressed serious anxiety as the victim has not been what the other agency will do. And this is not a case that we should hand over this. It is not an investigation. They are only searching out. Our purpose is not consider whether the investigation is properly being carried out or not. It is a habeas corpus petition.
Item 59.
We have received copies of the CD. That was
Prayed for some more time for carrying out rigorous search in order to locate the victim and recover. Stop. Prayers stands allowed. Let the matter be listed on 16th of August, 2023. Meanwhile, all efforts will be taken by the respondents number. Who is the appearing for? By the respondents number 2 and 3 for recovery of the victim. Stop. A copy of this order be furnished to Ms. Patnaik and International Government Advocate forthwith. In the next 58. And is 58, someone is appearing, Mr. Das, you are appearing. Who is appearing in item 58?
58. No, not mine.
Item 59.
None appears for the petitioner when the matter is taken up. However, Mrs. Patnaik and counsel was submitted before us a written instruction received from the IIC Agarpara police station. Wherefrom we gathered that oh, it is 57. All right, 57, keep it on record.
Madam, where is the instruction? Oral instruction regarding recovery, oral instruction.
No, 58.
Where?
58 they mentioned.
16th August. This instruction received from IIC Khaira police station, huh? It appears from the said written instruction that victim has been the appellant.
Item 18, my lord.
Now, 424, are you appearing there?
Yes, in the 24, I am appearing.
Mr. M.K. Kuntiel and Regional Government Advocate is appeared for the state respondent. Okay, what is the other matter?
Item 22, my lords. Parted matter, my lords. Lordship may take it up any date subject to your lordship's convenience.
Give a date. 24th of August.
Obliged.
Item 18, my lord.
What's the matter on 24th August 2022 is parted for continuation of hearing. Item
18. So this is a case, my lord. Then the tomorrow is fixed for contempt. May I pray, lordship?
Item 18.
18, my lord. So up to 17 before lunch. So I expect I could not make mention.
No order has been passed.
That order is passed for complaints of and what has happened in that case, my lord, that order has been recalled, the original order has been recalled. It's a batch of order passed in by the state administrative tribunal. We filed a writ petition here. Your lordship had directed us to file a review application. Accordingly, a review application was filed, and in that review application, that order was recalled. But in a contempt petition, if that entire order has been recalled, in that contempt petition, Honorable Single Judge is directing us to implement that order. So it cannot be possible to implement
And
that.
the order which has been recalled, contempt, you have been directed to.
Yes, that is the problem. Your lordship cannot take up today, madam. May I pray your lordship can take up this
Take it up
tomorrow
now, that
first case so that
first time it is
at
taken,
10:30
take
it
it up,
can be.
first order. Come up for the first time, no, he's saying tomorrow, again, same thing. There's a delay.
Additional government advocate. It is in IA 4105. So this is an application under Section 5 of the Limitation Act for condoning the delay of 33 days in filing the intercourt order, intercourt appeal.
May I pardon, my lord? I am
against the order dated 11/5/2023.
You're appearing in this matter?
Respondent, my lord. I'm appearing on respondent, my lord.
Very good.
I'm appearing on respondent.
Respondent.
My lord. 18 actually.
33 days delay.
So you have no objection against?
No objection, my lord.
All right, we are issuing notice against the order. You are challenging the order passed in contempt.
Yes,
because there was a specific direction made in the contempt.
No, my lord. But fact is,
Just a minute,
63,
I'm not asking you.
Annex 10. Page 63, Annex 10.
Annex 10, it is the order passed in contempt matter.
Yes, my
lord. Order dated 11/5/2023 as passed in contempt. Cont C number 2293 of 2023 by the learned civil judge. Issue notice. Since Mr. Who is appearing?
Gyanendra Chandra Swain, GC Swain.
Since Mr. You have not signed. Have you signed it?
Signed, my lord.
Your name is not there in the Vakalatnama.
Printed, my lord. Printed, my lord.
What is it? Printed? Oh, Mr. Gyanendra. Since Mr. GC Swain, learned counsel, appears in web's notice for the respondent. No formal notice is called for. We would request Mr. Kuntia, learned counsel, to supply a copy of this application for condoning delay to Mr. Swain in the course of day. Stop. Mr. Swain, learned counsel, has asked for a short accommodation for filing the objection against the prayer for condonation. Let the matter be listed on 16th of August, is all right? 16th of August 2022.
The fact is that only.
Wait. In WA, just pass an order, huh? Having regard to the nature of the case, we are of the view that till the next date, as fixed in IA number such and such, it's present IA, the operation of the impugned order dated 11/5/2023, Annexure 10 to the WA 1551 of 23 shall remain suspended.
My lord, fact is that, my lord.
Already will hear you. Two cannot go. We are issuing notice, and in a contempt proceeding, a specific direction has been issued, which is completely prohibited by law.
No, my lord, fact is that.
What will you consider? Apparently, you are staying in order passed in contempt proceeding.
Mr. Swami, we have not disposed of the application. You come and
are giving
argue.
opportunities 16(8).
All right.
You are taking the time for filing an objection, and another contempt proceeding will be listed tomorrow against them. We say that this operation of this order will be till then will be there. Let us consider, because normal principle is that when someone challenges the contempt case will not be taken by the court. Only information is sufficient. We have only stayed up to the next date.
Fact is that, according to order of the division bench of this honorable court, my lord, the matter has been dismissed, my lord. The order of the tribunal has been dismissed by the division bench of this honorable court. Thereafter, the single bench has passed order, my lord. That is the fact, my lord.
We are staying in order of the contempt proceeding.
That contempt proceeding.
Whether contempt proceeding, what can a judge can do? Tell us. What can a judge do? What is the power of the judge in a contempt proceeding? He either can punish or say that there is no contempt made out. And if the judge passed a specific and positive direction, that is appealable. He cannot usually do that. And that is the reason why just temporarily you are staying this operation. Let us examine it, whether that was passed within the precinct of law or not. Right. Come on 16th, only it's less than a month. Yes.
Item 63, my lords. Item 63, my lords. Because I am for the respondent. The decision of honorable single bench has been stayed, my lords. There, my lords, there is a direction I am to taken off into the work charge establishment. So every day I am incurring suffering, my lords. A short date may be fixed, my lords. Some conscious, my lords, can be taken, cannot be taken up for tomorrow or after tomorrow.
No, this is not possible. You are facing the short
date, my lords.
When it can be? 9th. No, don't fix 9th. 11th of August?
We'll do, man. 11th August.
10th of August, no? Stop. Let this matter be listed on 10th of August 2023.
Yes.
Anyone is appealing for the appellant in this matter?
State. I am appealing.
Interim order is there.
Interim order is there.
You are appearing?
Yes.
Mr. P.K. Mudalil and additional government advocate appears for the appellant. Where is Mr. D. Mahapatrul and it? You are for?
Well, I am for the respondent.
So,
For the appears for the respondent.
Sole respondent.
And what is the other matter?
Well,
interim order is.
Interim order is passed earlier, shall continue till the next.
Item 54, my lords.
54.
54. This is a writ appeal, my lord. I am for the appellant. The respondent has filed a counter affidavit in the meantime. I'll file the rejoinder. Lordship may kindly grant me 2 weeks time.
You will file or you have filed?
I'm for the appellant, my lord. I'll file the rejoinder in the meantime. There is an interim order, my lord, in this case.
step by step, wait.
Hello.
One time we'll adjourn, thereafter interim order.
At the request of Mr. A. Mohanty and counsel appearing for the appellant, let the matter be listed on 11th of August 2023. What is the rejoinder you will file?
They have filed a counter affidavit yesterday only.
Counter affidavit is the writ appeal.
Yes, ma'am.
With leave of the court or without leave of the court?
With the leave, my lord. The private respondent has filed a counter affidavit yesterday. We have got the copy. It is mentioned in the noting also. Lordship kindly see.
Already you can file the rejoinder. We are not mentioning because we have to examine.
Respondent number 3, my lord. The private respondent has filed a counter. The noting also shows the same.
No, whether the leave was taken from the court or not, that is our question before filing the counter affidavit. All right.
There is an interim order, my lord. Interim order is there.
Interim order is passed earlier, shall continue.
Like
Item 37.
At the request of such and such is the matter in such and such state.
Item 37, 38, 39, 40. Their interim orders are there. I will furnish the number. In some cases, interim orders are there.
Has to be a passing order. 31,
37, 38, 39, 40, 45, 47, 48, 49, 50, 52.
Just a minute, let him take note of it.
Sorry, man. Sorry, extremely sorry.
37.
My lord.
First 37, huh? Let the matter be listed on 11th of August. 38, same order. 39, same order. 40, same order. 40 also?
Yes, ma'am.
40 is already fixed. And then 41. No, 42
45.
has order passed.
45, my lord.
And 45. That's all?
47, 48, 49.
47, 48, and 49.
Then my lord, 50 and 52.
Just a minute. 50
and 52.
And 52.
Right.
At the request of Mr. M.K. Kanthial and Council, let the matter be listed on 11th August. Interim order is passed earlier, shall continue till the next date. In all the matters, same order, huh?